Casey, is my audio okay?
There was a bit of an echo there, but other than that, I could hear you.
I think I took care of the echo.
Yes, much better.
Good morning, everyone. My name is Harris Adams. I'm the administrative law judge assigned to hear proceeding number 23A-0330E. This matter comes on for hearing pursuant to decision R23-0524I. And probably should have done before. I'll call the hearing to order, but off the record a moment. Tracy, are you with me?
Good morning, Judge. I'm with you.
Good morning. Thank you. And Stephanie, you're still, Casey, you're still with me.
Yes, I'm here.
Thank you. Okay. Then we'll go back on the record and continue. Good morning, everyone. If we can start with the entries of appearance, and then we'll get into some preliminary matters.
Good morning, Your Honor. Stephen H. Gunman, Assistant General Counsel, on behalf of the Public Service Company. Also, I'm entering the appearance of Caitlin Shields and Sam Eisenberg.
Good morning. You're having some audio feedback. Perhaps you have a speaker playing with the mic, maybe, if you can try to sort that out for us.
I think we have, Your Honor. Thank you.
And for QTS.
Good morning, Your Honor. Mark Valentine from the law firm of Keys and Fox on behalf of QTS.
Good morning. And CEC.
Good morning, Austin Rushaw from the law firm of Holland and Hart on behalf of CEC, and I'm joined by my colleague Michelle King.
Good morning. Climax.
Good morning, Your Honor. Richard Fanyo for Climax Molybdenum Company.
Good morning. Probably should have started here. Let's see. No, there we go. UCA.
Good morning, Your Honor. Senior Assistant Attorney General Gregory Bunker, representing the Office of the Utility Consumer Advocate, and joining us today, representing the UCA, is Kate Crampton, Assistant Attorney General.
Good morning, Your Honor.
Good morning. And for staff.
Good morning, Your Honor. Kevin Opp, Special Assistant Attorney General, representing staff.
Good morning. Okay. And while we've got all the parties on here, let's see, have the party, I do have a cross-examination matrix that the parties provided, and thank you for doing that. Have the parties addressed order of presentation?
Your Honor, I believe that we have. My understanding is that we will be proceeding in the order of the cross-examination matrix.
Okay, I think I'm going to ask to adjust that a little bit. I think we'll have QTS. I guess this is actually fine for the order of cross-examination, I guess. But actually, maybe not. The order of presentation, I think QTS should present their case after public service and cross first. Seems to me you're reading the pre-filed testimony, your positions are aligned. In fact, QTS is, of course, a witness for public service. So I think we'll have public service present, then QTS present. I expect minimal cross-examination, if anything, from QTS on the company. And then we'll proceed in the order after that on the matrix provided. So if that you can.
That's fine, Your Honor. Thank you. I don't have any witnesses. Mr. Wright is testifying on behalf of the company. I'm just here to cross-examine. So
Okay. Thank you. But I'll let you go first in your cross then.
that's fine. Thank you.
Thank you. And so, Your Honor, just to clarify, that means the order of public service witnesses will be Mr. Bailey, Mr. Rurup, Mr. Rozak, followed by Mr. Wright from QTS. Is that correct?
I'm sorry. I'm more concerned about party. You can present your witnesses in any order you wish. So I realize what I'm wanting to do is to get your case closer to QTS in the sequence, so that other parties will have any cross from QTS first. We'll see if it works.
Yeah, I think at this point we had Mr. Wright from QTS as the second witness.
That's fine.
And we'll leave him in that order. Okay, thank you.
If you would like.
Understood.
Okay. All right, then I have a couple of preliminary matters. I'm well aware of the parties' pending motion to dismiss, motion to strike. I was not able to get that decision processed and issued prior to today's hearing, so it's my intention to announce the ruling orally, and it'll be memorialized in a written decision. The commission has fairly limited experience in applying the EDR statute. There's been a few proceedings, and only a few proceedings, and I've reviewed the decisions in those cases significantly. And one of them, it is, of course, the partial settlement of Public Service Company's case affecting EDR and then in the standard contracts, especially in 23A-0330E. So that wasn't a fully litigated proceeding. I think that's at least noteworthy in looking at the commission's decision and reading the scope of the decision itself. And of course, then also Black Hill's case in 2019. And looking at those and applying the rules of statutory construction that I will do as required by law, I then go through the specific requests for striking testimony. And I will begin with what I'm going to refer to as duplicative testimony. In the OCC's case, Mr. Neal and Mr. Fernandez both attach identical documents to their testimony. And in Mr. Fernandez's testimony, he attaches RAF2 and identifies it only as answer testimony of Mr. Chris Neal in proceeding 22AL0530E. In the pre-filing of testimony in the case, the actual attachment does indicate a caption for 22AL530E. However, it's labeled as Hearing Exhibit 302, Answer Testimony of Chris Neal, Rev 1, in proceeding 21AL0530E. In the body of the testimony at page 22, there's only one sentence that relates to or references the attachment. And it is, of course, the UCA reference to Mr. Neal's testimony for a general statement in the testimony. To Mr. Neal's testimony, whose, of course, testimony it was in the other case, he has attached attachment CN3. In his listing of testimony, identifying the attachments, he describes it as the answer testimony of Chris Neal, revision 2, at page 10, table CN1. Again, the actual file attached in the pre-filed testimony is the identical document, as I said before. And in his testimony, there's again only one sentence that even refers to the attachment, and it's noting the UCA notes that transmission costs have substantially exceeded estimated costs in several recent cases. And again, he's referring to the table in the testimony. There's no other reference in the attachment to his testimony. I've reviewed commission files in proceeding 21, or excuse me, well, first, there is no proceeding 21AL0530. There's a 22AL0530. Excuse me, I may have said that backwards, but there are not both of them. In either way, there is no Rev 2 of hearing exhibit 302 in the proceeding. In the procedural order for this case, I indicated that parties should not file duplicate hearing exhibits. And as a result of the duplicate exhibits, there is confusion in the record. They're wholly cumulative, unnecessary, and it's Mr. Neal's testimony in another case. I feel like he's the best witness to testify about the issue in this case. And he's available to have testified here. As to Mr. Fernandez, Mr. Neal's prior testimony is entirely hearsay. The general statement in the body of the testimony is this one sentence, and doesn't seems to me the attachment is not warranted. It's almost 50 pages, purely hearsay, and Mr. Neal is here, as I said before. So I'm not going to strike these statements in the testimony. However, I am going to strike the attachment RAF2 in its entirety. And as to Mr. Neal, I think I'm going to strike the exception of what he, except as to what he identified in his own testimony, which is page 8 of attachment CN3 that has the table he referenced. As to the remainder of the motion to strike, I find that public service failed to meet the burden of proof to show that the subject testimony is not relevant to any consideration the commission could undertake in this proceeding in deciding whether to conditionally or unconditionally approve the EDR ESA. Conclusions underscored by the review of the prior commission decisions and the scope of considerations there. I think this is also a case of first impression as to a non-standard EDR for public service. I'm not saying there's no merit at all in the argument in the least, but I do believe that appropriate weight can be assigned, and the question testimony will not have risk of prejudice or cause substantial delay or waste of resources. I hope that this will streamline our examination through the hearing. And with that, at an appropriate point, which will be before long, we'll have to figure out getting the new version of attachment CN3 to hearing exhibit 201. And again, that ruling will be memorialized in more detail in a written decision that will issue in due course. My next preliminary matter I want to address, Mr. Opp.
Your Honor.
Yes.
Your Honor, Greg Bunker for the UCA. Just to clarify, with regard to your ruling on Mr. Neal's testimony attachment, are you, am I correct in understanding your ruling as refile that attachment CN3 with, I guess it would be just the caption page and the page that Mr. Neal's testimony that has the table contained on it, and essentially just those two pages rather than the entire testimony?
Yes, thank you for the clarification. But you don't need to file it. If you'll put it in your box.com folder, I think we could address it through there. And we'll admit it through box.com rather than the spreadsheet that we're going to get to here momentarily.
Very good. Thank you.
Thank you. Mr. Opp, I had a preliminary matter to address with you. You were contacted by the legal assistant preparing for today's hearing that it appears to us there is no copy of Ms. Segala's attachments 1 and 14 in a public forum. It's only filed as a confidential exhibit. I asked the legal assistant this morning, and it appears that there is not a public copy of that in your box.com folder as requested. So when do you have that available now, and are you ready to proceed with that? Or actually, I need it in the box.com folder even if we don't handle it this moment. Do you have
Sure.
that?
Yeah, I asked my assistant to put it in there. She said she was having some issues logging into box.com. She literally just came in and told me that. So during a break, I'm gonna talk to her and see what's going on. But we have those. So as soon as we can get them in there, we will do so. We attempted this morning, or she attempted, and for some reason wasn't able to do so. So I'll try and work with her during a break to get that in there.
Okay. And then next thing is now getting to the hearing itself. We are, of course, conducting this hearing utilizing electronic pre-filed exhibits as much as practicable. A spreadsheet was prepared to use for navigation and identification of the pre-filed documents in the Commission's administrative record. The spreadsheet indicates the latest versions filed for each document. The spreadsheet's been marked as Hearing Exhibit 700. It reflects the date of the latest filed version as it appears in the Commission's administrative record, a title referencing for hearing exhibits that will be used during the hearing, and the title of the document as reflected in the Commission's record. Excuse me, if those may differ. Because attachments to testimony are part of the hearing exhibit, references to attachments to testimony will include reference to the hearing exhibit. I'd ask parties to refer to the attachment to a pre-filed exhibit to reference both the exhibit number and the attachment. For example, if you intend to refer to a witness attachment ABC1, it'd be most helpful for all of us following along if you would refer to hearing exhibit X, whatever the number, attachment ABC1. Any item listed in the spreadsheet that is admitted into evidence will be admitted by administrative notice based on the existing filing referenced in the Commission's file. As such, those portions of the administrative record would become part of the evidentiary record. The fact being administratively noticed is that the electronic pre-filed copy in the administrative record is the content of the otherwise admissible exhibit being admitted. Separately, we will of course be admitting additional exhibits as they arise through the box.com process. So with that, the exhibit 700 was distributed. For right now, it does include the confidential versions of Ms. Segala's attachments 1 and 14. And I will ask if any party reviewed and had any concerns, questions, problems reviewing the exhibit 700.
Your Honor, not from public service. The only note that I will make is that on, I believe it was November 13th, we filed an updated version of Mr. Jason Rurup's attachment, I believe JAR2 and JAR3. My understanding is that the spreadsheet has been updated to reflect those corrected exhibits, but just wanted to clarify that we made that correction.
JAR2 is based on Rev 1, filed November 13th. Which was the other exhibit?
I have confidential attachments JAR2C and JAR3C, which accompany hearing exhibit 106.
2C is again Rev 1. 3C.
Right, I'm just noticing in hearing exhibit, the spreadsheet, that the filing date listed is 10/24 for each of those. And so the corrected version is the November 13th version that we have filed.
Judge, I'm sorry, if I can chime in. I think, Ms. Shields, you might be looking at the old version of 700. I see a 11/13 filing date for JAR2 and JAR2C, as well as JAR3 and the two versions, or I'm sorry, the confidential version of JAR3C.
Ms. Frederico, I also see the October 24th executables. The filing date on the executables is still 10/24.
I didn't hear her list the executable in her that she refiled.
Okay.
So-
But okay. That's right. So both of the executables are still 10/24, and but the 2C are both November 13th.
Yes, and 3C. 3 and 3C.
Are you satisfied there, Ms. Shields?
Yes, thank you very much.
Okay.
If we have any, I don't want to delay the beginning of the hearing. So if we have any other issues, we'll follow up later.
Okay, well, I'm going to ask now then, does any party have any objection to proceeding along the process of admitting exhibit 700 to admit by administrative record the incorporated documents? I'm not going to admit it at this time, as we may have to make modifications through the hearing. All right. Then I believe now those are the preliminary matters I'm aware of. Is there any others that anyone else needs to address before we get going?
The UCA has one, Your Honor, and that is that Mr. Fernandez is unavailable on Monday, and so he may need to be taken out of order on tomorrow, Friday.
Okay, I think we have some runway to deal with that, but thank you for the heads up there.
Thank you.
Okay.
Your Honor, one quick one.
Sure.
This is Richard Fanio for Climax. The matrix shows that we reserved 15 minutes of cross for Mr. Bailey. We're waiving that.
Thank you for that. And while we're on that, then, is there any other cross that anyone knows they're waiving now? We could go ahead and clean this up a bit. If not, we'll go through it.
Yep. Yes, Your Honor. QTS is going to waive Mr. Neal. I believe I have a half hour.
I've got a 0 on Miss.
Good.
No, I'm sorry. I was looking at Ms. O'Neill. Okay, thank you for that. Okay.
And then, Your Honor, from staff, Mr. Dalton will be adopting the answer testimony of Mr. Greb, which is hearing exhibit 303. And I already informed the parties of that, but I'm letting you know as well.
Okay, thank you.
And if we could just clarify with Mr. Opp that Mr. Dalton will also be adopting any discovery that was sponsored by Mr. Greb.
Yes.
Thank you.
Okay. All right. Mr. Denman.
I'll turn things over to Ms. Shields.
Apologies.
All right.
Is he on?
Go ahead.
Is that better?
I think so.
Well, now I can't hear. All right. Are we good now?
For right now. Are you in the same room as Mr. Denman?
Hang on one moment.
We'll go off the record just a moment as let's sort out the technical issues and make sure everybody can get on at the same time.
Thank you, Your Honor. I think we have sorted them out on our end.
Okay, Mr. Denman, can you tell us hello then?
And Your Honor, I will be presenting public services first witness.
Okay, well.
And Your Honor, I have muted my microphone, so I'm not sure where that echo is coming from.
Okay, well, so far we appear to be okay. All right, thank you. Okay, then we'll go back on the record. Ms. Shields.
Thank you. And one other brief preliminary matter. I did just want to flag, there is some confidential information in the record. One of the important pieces of confidential information is the level of discount that we are proposing for QTS. And so to the extent that there is going to be cross-examination on that piece of information, we just wanted to flag in advance that we may need to go into confidential session.
Thank you, and I appreciate your pointing that out as a reminder for all the parties. Of course, appropriate people who've had access to that information have executed the appropriate NDA, non-disclosure agreement. And so if we do need to get into that confidential information, we will take appropriate precautions at the time for the company as well as a party who may raise it through cross. If you anticipate going into something in that arena, please stop before asking the question and let me know so we can take these appropriate precautions. Thank you.
Thank you. I believe with that, we are prepared to put our first witness, Mr. Thomas Bailey, on the stand.
Mr. Bailey. Not seeing him on my screen. Okay, now I do see him. Mr. Bailey, if you would please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Ms. Shields.
All right, Mr. Bailey, if you could please state your name and title for the record.
Yes, Thomas L. Bailey. I am the Senior Director of Corporate Economic Development for Excel Energy.
And are you the same Mr. Thomas Bailey who submitted direct and rebuttal testimony in this proceeding?
I am.
And the same who adopted certain portions of Mr. Steve Wishart's direct testimony?
I am.
And if I were to ask you those same questions today, would your answers be the same?
Yes.
And Your Honor, I believe that we have moved into that the testimony has been admitted into the record. Is that correct? Or should we be moving on an individual basis?
No, that's actually, I was catching up myself. I should have addressed that in Exhibit 700. And it is my intention to do so to minimize other than adoption of testimony as to foundation and that type of thing. So I'll interrupt your examination just a moment to take care of that. Again, as I mentioned earlier, we've circulated hearing Exhibit 700 that identifies those pre-filed documents in the Commission's administrative record. I'll now ask if there is any party that has any objection to the admission of the hearing exhibits identified in hearing Exhibit 700, with the exception, I'll leave staff's confidential exhibits based on the representation of counsel that we're going to get that resolved. But Mr. Neal's attachment that I addressed earlier will have to be replaced in the spreadsheet. So I'll say all documents admitted or offered in hearing Exhibit 700. Is there any objection to the admission other than the attachment to Mr. Neal's testimony?
Not from public service.
Not from the UCA.
No objection from CEC.
Nor from QTS.
No objection from staff.
And no objection from Climax.
All right, thank you. Okay, then those exhibits are now admitted and we'll not need to spend much time on foundation there, except as we mentioned, where those witnesses are adopting the testimony of others, feel free to address that. But those exhibits are now admitted. And so Ms. Shields.
Thank you, Your Honor. With that, I'd like to make the witness available for cross-examination.
Thank you. Mr. Valentine, I'm assuming nothing, but I'm going to ask you each time if you want to jump in for cross or clarification.
Thank you, Your Honor. No cross.
Okay. And then I think it's the party's intention that staff would go next.
Thank you, Your Honor. Good morning, Mr. Bailey. How are you?
Good morning. I'm well. Thank you for having me here today.
Thanks. I don't think we've met before. My name is Kevin Opp. I represent staff in this proceeding. And so if you can we please turn to hearing Exhibit 105, your rebuttal testimony, and starting on page 10. Then if we can scroll down to lines 19 through 22. And so I want to focus on this last sentence in this where you say staff and UCA now attempt to walk back their commitments and important facts of the EDR settlement they signed on to while simultaneously ignoring or mischaracterizing other key commission findings from that proceeding. So let's talk a little bit about that. So first, I want to see if we can agree on certain things. You'd agree that the settlement in that EDR proceeding, that was under the standard economic development rate, correct?
For clarity, I wasn't part of the settlement. I've read through it, but not only did it cover the standard, there is reference to non-standard in the requirements that we bring a contract to the commission for approval.
Okay, all right, well, I'm glad you clarified that. So, because you have reviewed that settlement agreement, correct?
I have. I was hired 2 months prior to the unopposed agreement and signatures.
Okay, so let's talk, well, so coming back to what I said, that was intended primarily to apply to the standard EDR proceedings. Would you agree with that?
Again, there are,
Objection. The witness has already indicated that he was not part of that settlement, and now he's being asked questions on the intent of the settlement agreement.
Well, I mean,
Well,
he makes representations about how staff and UCA are walking back their commitments to staff. He said he's reviewed it. I'm kind of stunned with the objection.
I'll overrule the objection. I think that the witness is talking about the positions and has addressed the settlement in his testimony. I think he's subject to cross-examination on it. I will mention, though, because I think this is going to come up more than once. I'm mindful that the commission approved that settlement, and that settlement is now an attachment to the decision in the proceeding. The commission has issued a decision in that proceeding, and the document itself is going to be controlling of what it says. So I hope we can minimize cross-examination of what the document actually says. I'm not saying there's no additional cross needed, but hopefully that'll streamline it a little bit for us. So the witness can answer the question. Do you have the question in mind, sir?
could you please restate the question?
And I'm asking a very simple question, and you keep expanding on it. My question is specifically, that was intended primarily for the standard EDR, correct?
And I'm going to sustain that. It's the intent. I mean, the document speaks for itself.
Okay.
So,
that's fine. And so I'll just focus on a couple. Just in general, I'm not going to read verbatim because I'm actually mindful of your Honor's statement that's in the record and it speaks for itself. Let me ask you this, Mr. Bailey. As part of your review of the settlement agreement, did you review the general provisions section of the agreement?
Can you point me to where that?
That'd be on starting on page 19.
On page 19, I have.
Okay, and so when you made this statement in your rebuttal testimony, you took into account the general provisions, specifically paragraphs 1, 2, and 4.
I've read through and reviewed. I think it's important to denote that while it doesn't bind a settling party, it does state and require a form of precedent because it was passed as a legislative statute.
Mr. Bailey, I didn't ask you anything about that. My question was, it'd be a lot easier. You'll have the opportunity, your attorney will have opportunity to clarify. My question was fairly straightforward. All I asked you was when you wrote your testimony, in terms of you took into account the general provisions, including paragraphs 1, 2, and 4. That's all I asked.
Those provisions are part of the settlement agreement.
Okay, and you took that into account when you made that statement in your rebuttal testimony, correct? About moving away from provision that staff and UCA are now trying to walk away their commitments, correct?
I took into account the entire settlement agreement and the requirements of the statute.
Okay, thank you. So, all right, does the standard EDR tariff apply to QTS?
The standard EDR tariff does not, because they will have a load greater than 20 megawatts as defined in the statute and is outlined as a requirement in the settlement agreement of greater than 20 megawatts.
Okay, and you'd agree that public service QTS states that that QTS could have over 250 megawatts of load, correct?
They have provided us an expected load ramp over that 10 years. I believe initially we're modeling approximately 160 megawatts, but they have the opportunity with the capital and the build out to obtain 250, I think it's 252 megawatts.
Okay. And so that load is far greater than the limits that are in for that are under the standard EDR tariff, correct?
Well, they're far greater as defined in the statute and the requirement that we come to the commission for approval.
Okay. And so you'd agree that because the load is different and it's larger, so the point of doing on the non-standard EDR contract, and like what we're doing here, is to evaluate it on a case-by-case basis.
As required in the statute.
So is that a yes?
Yes, we are following the legislative statute as passed by the Colorado law.
All right. So again, let's go to page 20 on hearing exhibit 105. And let's look at lines 12 and you reference this settlement agreement in your you reference that settlement agreement that we're talking about, correct?
Yes, at the bottom, at the beginning of line 20.
Right. And so I just want to say here, coming back to some of the things you said in answer to my question, you said that it has some it refers to non-EDR, but here you say that the EDR settlement only applies to the standard EDR contract enrollment, correct?
Can you show me which line you're referencing?
Yeah, line 16.
Referencing the cap of 130 megawatts as it relates to the standard EDR contracts submitted for enrollment.
Okay, but so all right, I'll let it speak for itself because I'm a little no, I'll move on. So the EDR proceeding established a cap specifically of 130 megawatts, correct?
The standard EDR has a cap of 130 megawatts. Those are for customers between 3 and 20 megawatts.
Right.
There is no cap as we bring non-standard contracts to the commission. That's why they come as a case-by-case basis to be approved. So the cap does not apply to QTS or future customers who are greater than 20 megawatts.
Okay. Let's move on. Are there any current does public service have any customers that are taking service on the standard EDR rate? And thank you. I don't need hearing exhibit 105 right now.
Can you restate that? I'm sorry.
Yeah, I did say something in between. I apologize. Does public service have any customers that are currently taking service under the standard EDR tariff?
We do not, but we have filed and it has been approved for a new customer that we taking service. I believe, I don't know the exact date, but I believe sometime in 2024 in the Denver metro area.
And so QTS, and I want to make sure I say this correctly, QTS could be the largest, if it takes the load anticipated up to 250 megawatts, that would represent public services largest customer in terms of megawatt loads, correct?
I would need to confirm the current customer base, but it will be one of our top customers. That is accurate.
Okay. Now, QTS is intending to operate as a master meter operator, correct?
Yes,
Okay. And QTS is going to be a data center, correct?
they will be operating and leasing to tenants who will be utilizing machine learning, AI technologies, and overall data center industry requirements.
And doing that as a master meter operator to its tenants, correct?
That is accurate. We will set and serve QTS as our customer through one transmission meter.
Correct. And then QTS will then, as a master meter operator, allocate the electricity or the electric service to its tenants, correct?
I can't speak to how QTS will define their tenant contracts. That's not our right or our business. Again, QTS will be our customer, and we will provide them service at one single meter.
And they will be operating as a master meter operator, correct?
They will be a master meter customer.
Okay. Do you know, does public service have any all right, let me lay a foundation for this. Public service has other customers that operate as electric master meter operators. Is that true?
I'm sorry, can you restate that?
Yeah, does public service have other customers that also operate as an electric master meter operator?
Without checking the customer base, I presume that is yes. It could be a master meter of a commercial building, an tenant building, an apartment building. That's pretty standard, not only in the state of Colorado, but throughout the US, and how utilities potentially serve tenant customers and master meters.
Okay, well, you said potentially. Are you aware, you said residential, but you also mentioned commercial. Do you know if public service has any non-residential or commercial electric master meter operators as customers?
Yes, I expect they do. Most utilities will can serve could be a commercial business or strip mall with one meter. That is not a unique service capability of a utility.
Okay, well, all right. So you said that my question was if they have any customers. You said that you presume that they do. Is there another witness from public service that could answer that in a more definitive manner?
Maybe potentially witness Rozak.
What witness was that again? I'm sorry.
Rozak.
Okay. Okay. Thank you.
I also think, witness Rurup from a rate and regulatory side, maybe provide that too. Again, because I'm not going to provide data if I don't have it in front of me.
Yeah, and that's why I want to clarify, because I just want to make sure. I don't want to ask you a bunch of questions that you don't have the base for. So I appreciate that. Okay. So let's take a step back. What was your role in terms of dealing with QTS and coming forward with this application?
Thank you. I think it's helpful to give maybe a little bit of a time frame
Sure.
of my role and responsibilities. So if you start chronologically with the passage of the statute in 2018, 2019 began the discussions and attraction of QTS. I was hired January of 2021. My team, along with the PSCO leadership team and account management, took the lead in attracting the customer. It was a competitive attraction throughout the US. They have operations in other states, and so they did reference the importance of the EDR statute and why they would come here. We went through the proper, as I considered the proper utility channels internally to discern appropriate service levels, the transmission requirements, the collection of funds. We got to a negotiated contract and a transmission agreement defined not only on their service requirements, but their requirements to pay 100% of the transmission costs. And then we completed the negotiation for the EDR credit for the non-standard agreement as defined in the statute. We then followed the procedures, had signatures, and went through the proper filing status as required in the statute.
Okay. So let's talk about that. Let's talk about QTS's expected tenants. Did QTS provide public service with a list of its proposed tenants?
They did not.
Okay. And so I just want to clarify, and I think we know, so each one of their, as a data center, QTS will have various tenants taking service, correct?
Not being an expert and not speaking for them in their business model, but they have the opportunity, depending on their build out and their strategy, they may have multiple tenants. Conversely, compared to a hyperscale facility that may be one tenant, and that doesn't remove the opportunity for hyperscale data centers to lease or rent out to others. So it's depending on their business model. Not only did they not provide us tenants, we are not required to request and ask for those. That is up to them how they serve their customers, and we will provide them service as the utility provider.
Okay. So I just want to clear, you didn't ask them for the proposed tenants?
No, I did not.
Okay. Well, did someone in public service as part of the negotiations ask that? Was that ever provided? Let me put it another way. Has QTS ever provided public service with a list of its proposed tenants?
No, they have not provided that.
Okay. And so could QTS have a tenant that's already taking electric service in Colorado?
Technically, they could.
Okay.
Again, we do not require the identification.
Okay. And so it's also possible that a QTS, one of its tenants, could move its operations from, say, another service territory, Black Hills service territory, to QTS, and therefore under public services service territory?
It's certainly an opportunity that they have. Again, businesses make their decisions on how they run their business, and based upon location, based upon demand, that would be up to QTS and their end use tenant.
Okay. And I just want to clarify, I actually don't have much left. I want to clarify, you mentioned hyperscale data center. Can you give a little color on that? What you're referring to when you mentioned hyperscale data center?
I certainly can at a very high macro level. You would think of maybe the top 4 well-known service providers who would have one campus, and they would fall under their requirements for their own utilization. So cloud services, you think of maybe Google or Meta or Amazon, and they may have one building, may have multiple buildings, but they consider that as a hyperscale that is utilizing their computing power for their needs.
And so do you know in the discussions that public service had with QTS, was it contemplated that QTS would have multiple tenants? Was that part of the discussions?
We understood from their strategy that that is their business model.
Okay. And so those multiple tenants in aggregate, they'll be the ones maximizing the full megawatt service from that QTS is taking from public service, correct?
Depending what investments they make with their computing power and their docks and shelving. So it's up to them on how they're going to be utilizing and at what rate, but they are effectively will be what's driving the demand for utilization of the facilities that QTS will be building and owning.
QTS has already started constructing its facilities here in Colorado, correct?
That is accurate.
Okay. I have no further questions. Thank you, Mr. Bailey.
Thank you very much.
Thank you, Mr. Bunker.
Thank you, Your Honor. Good morning, Mr. Bailey. My name is Greg Bunker. I represent the utility consumer advocate in this case. Nice to meet you.
Good morning. Nice to meet you. Nice to see you.
Let's start perhaps in an area that Mr. Opp started with, and that is, let's turn to your rebuttal testimony. Hearing Exhibit 105 at page 12, starting on lines 21 through page 2 on page 13. And here you're taking issue with UCA and staff testimony, and to use your words, that raise a litany of policy concerns regarding whether or not the legislature intended this particular customer to merit an EDR. And you say these broad-based policy concerns have no merit and are not supported. Is that correct?
Yes, as it moves into line 13 and page 13, line 2.
Yes, thank you. And if we could now look at Mr. Fernandez's answer testimony, hearing Exhibit 200 at page 22. Starting at line 13 and going on to page 23. At line 2, in part, Mr. Fernandez states, and I'll wait till we get there. I'm sorry, I'm going a little fast. Page 22, starting line 13, and on to the next page 23, line 2. And in this testimony, Mr. Fernandez states in part, data center companies such as QTS are not a good fit for what the legislature intended with the EDR statute, and that the legislature envisioned providing energy subsidies for companies providing substantial employment opportunities in Colorado, and that QTS will only employ a small number of jobs. Do you see those comments in that testimony?
I do see those comments.
Yeah. And is it your understanding QTS expects to employ approximately 25 to 30 full-time employees on this campus?
I believe the number is larger than that on full-time. I think it's maybe 50 to 75. I will make an additional comment here. While I'm not going to speak to the intent of the legislation, I think looking at holistically, the economic impact is extremely profound. There are going to be approximately 1,500 construction jobs over the first 2-year period. It's going to generate probably approximately $80 million in salaries. The overall economic impact as defined by the U.S. Chamber of Commerce.
Mr. Bailey, I will acknowledge what you're saying as your testimony, and your counsel certainly can go into this on redirect. But my question was, how many employees would QTS employ on a full-time basis? And why don't we take a quick look at Mr. Wright's direct testimony, hearing exhibit 102. On page 11, I'll wait till the document gets accessed. Page 11, starting on line 13, here Mr. Wright talks about the employment. And if you'll see on line 13 through 15, the QTS campus is expected to employ 25 to 30 full-time operations and engineering professionals. Is that right?
That is accurate on line 14. It does not take into account the continued testimony on line 17.
Correct. And those other jobs, those are jobs that are created, as it says on the end of line 15, tenants within the campus, and on line 16, contractors that will be employed by those tenants. Is that correct?
Objection. To the extent Mr. Bunker is asking Mr. Bailey about the truth of the matter asserted within this testimony, Mr. Wright from QTS is going to be available as a witness for cross-examination.
And Your Honor, this witness has talked about these broad-based policy concerns that have no merit. And I'm trying to get into I'm trying to find a better understanding with Mr. Bailey's testimony as to what he means with regard to the employment at this facility.
Well, Ms. Shields, I agree. He'll have the opportunity to talk to the witness that actually wrote this testimony. So I'm not going to foreclose the subject matter, but it seems like maybe we could ask Mr. Wright a question about what he's saying, or give him the assumed employment numbers if you're trying to, but don't try to get him to testify to what this witness is testifying if he doesn't have the foundation to do so. So perhaps you can rephrase the question that you're trying to get to the witness.
Well, thank you, Your Honor. Setting aside the discussion on the construction jobs that the construction transmission construction agreement would perhaps generate, I'm asking the question about the QTS employment at the data center, not the construction piece of it, that the employees, the full-time positions at the data center once it's constructed. And if you have an understanding what those numbers might be.
Could you, I think it moved on to, is there an actual question there you would like me to respond to?
Yes. Do you know the number of full-time operations and engineering professionals who are likely to be employed by QTS at this campus in Aurora?
Again, only as it's stated in this testimony.
Okay.
But I would add to the fact of your previous question talked about policy and intent. I will make a statement and a note to the statute does not have a job requirement in the EDR statute as it was passed by the state legislature.
Okay, thank you. If we could access UCA's box.com account and UCA hearing exhibit 203, please. And this is a copy of House Bill 18-1271. And Your Honor, I would ask that we take administrative notice of this document.
Any objection to the admission of hearing exhibit 203 by administrative notice? Hearing none, exhibit 203 is admitted.
Your Honor, we generally don't oppose in concept. However, is this the signed version of the bill?
Let's scroll down, please, Ms. Federico. It appears it's not the signed version. Go back to the top, please.
We have no objection to taking administrative notice of the bill. We have a signed version of the bill marked as hearing exhibit 152 in our box account. So,
okay, then let me correct that. We'll not admit exhibit 203. Ms. Federico, can you pull up hearing exhibit 152 from Public Services box account? And can we go down to the end of that document? There we go. Mr. Bunker, is that the document you intend us to take administrative notice of?
Yes, Your Honor, it is. I note that on the copy of the document I had, it was the final legislation that was sent to the governor's office. And this is a more, exhibit 152 is a more accurate representation. So I would not object to its admission, and I would like to use that document in my cross-examination.
Of course, then I'll ask any other objections to the admission of hearing exhibit 152 by administrative notice.
no.
Hearing exhibit 152 is admitted, and you're free to use it, Mr. Bone.
Thank you, Your Honor. If we could scroll back to page 1. And at the towards the middle of the page, you'll see in bold print section 1 legislative declaration. Do you see that?
I do, thank you.
Okay. And if we could look at paragraph 1A of the legislative declarations, it states the General Assembly hereby finds and determines that the health, safety, and welfare of the people of the state, of our state, are dependent upon the continued development and expansion of opportunities for employment in Colorado. Do you see that?
I do, under subsection A.
And if we could refer to your direct testimony at page 11, on lines 1 through 4, here you actually talk about House Bill 18-1271, and you state that the General Assembly's legislative declaration in enacting HB 1271 emphasized the importance of economic development and the expansion of employment opportunities for Coloradoans. Is that right?
Yes, lines 2 through 4.
Okay, thank you. Let's go back to your rebuttal testimony. Here in Exhibit 105. And on page 10, and at lines 15 through 22, here you discuss Public Service's initial EDR application in proceeding number 23A-0330E and the settlement therein, correct?
Yes, lines 16 through 18.
Okay. And on lines 19 to 22 on that page, it's your contention that staff and UCA now attempt to walk back their commitment to important parts of the EDR settlement they signed on to, while simultaneously ignoring or mischaracterizing the other key commission findings from that decision, findings from that proceeding. Is that right?
Yes.
Okay, if we could go into the UCA's box and bring up hearing exhibit 204. And I will represent to you that this is and to the judge, this is a 57-page document, which is decision C21-0333 in proceeding 20A-0345E, and attached to it is attachment A to the decision, which is the unopposed partial settlement agreement in proceeding 20A-0345E.
Ms. Frederica, would you scroll through the document for us? And as she is, Mr. Bunker, you're saying this document that we're seeing pre-marked as 204 includes both the decision and the attachment?
Yes, sir, I am. And Your Honor, I believe it's at around page 30 or something like that, where the settlement agreement starts as part of this 57-page document.
Thank you.
There it is right there. That is the start of so it's page 34.
Okay. Any objection to the admission of exhibit 204 by administrative notice being decision C21-0333 in its entirety?
No.
Exhibit 204 is admitted.
So if we could scroll back to the top of the document at page 8. This is part of the decision. And here in paragraph 27 on page 8, the commission decision talks about the fact that public service proposed an EDR program comprising a standard EDR contract and a non-standard EDR contract. Is that right?
That is accurate.
And then you'll note, if we turn to page 10, paragraph 32, the commission now says, turning to non-standard EDR contracts. And in this particular case, this application with the public service and QTS contract, we are talking about a non-standard EDR contract, correct?
That is accurate as defined in the statute, in the requirements for us to file.
Okay, so in paragraph 32, the commission notes that with respect to non-standard EDR contracts, that public service proposes that they would be available on a case-by-case basis to qualifying EDR customers seeking to add or expand load over 20 megawatts, that the rates and terms of these contracts would be individually negotiated, and public service proposes to file a separate application for approval of a non-standard EDR contract. Is that right?
Yes, as stated here.
And with respect to this application proceeding, public service and QTS, let me rephrase this. With respect to this application proceeding and the public service and the QTS non-standard EDR contract, it reflects rates and terms that have been individually negotiated. Is that right?
It has, as required by the statute and the settlement agreement.
Okay. Moving to page 11 and paragraph 36 of the decision. The decision indicates that public service proposes to file annual EDR reports by June 1 of each year, and the company agrees to report the summary information associated with EDR customers taking service under standard and non-standard EDR contracts, right?
Yes, as stated in this document.
And if we could pull from the UCA's box account, hearing exhibit 206. I'll represent to your honor and to the witness. This is a 4-page document, and the first 2 pages are the 2022 annual economic development rate report, and page 3 and 4 are the 2023 annual economic rate report.
Okay, Ms. Frederica, again, if you'll scroll through a little bit, let's take see. Okay, any objection to the admission of exhibit 206, the 22 and 23 reports filed by public service and 20A-0330E?
I mean, the documents look authentic to me, but he has not laid any foundation with this particular witness, and I did not see this witness's name on this report. So I might ask for a little more foundation with the witness.
Mr. Bunker?
Your Honor, we just talked with the witness about the fact that paragraph 36 requires public service to file annual EDR reports June 1 of each year. And I believe Your Honor can take administrative notice of documents in its file, and this refers this collective document of the 2022, 2023 EDR report is what is referenced in the decision at paragraph 36. And then I want to ask the witness a couple of questions once this is admitted.
Okay, Ms. Shields, I think he's asking for administrative notice of these 2 filings by the company, not based on the foundation to be laid by the witness. So I guess the question to you right now is, do you have an objection to admitting exhibit 206 by administrative notice as being the filings of public service company referenced in 20A-0345E?
No objection.
Exhibit 206 is admitted.
Mr. Bailey, if we could take a look on page 1 and at the bottom of that single paragraph that's on page 1, and it's 2 sentences from the end, so roughly 5 lines from the end of that paragraph. The report says at the time of this filing, and this is the 2022 report. At the time of this filing, public service reports that it does not have any EDR customers taking service under a standard or non-standard EDR contract to report on. Is that a correct reading of that?
Yeah, I would ask that you allow me to consume this last paragraph, considering that I had not read it or sponsored it.
Sure, take your time. And you can ask Ms. Federico to move the document around if you need to see a different portion of it.
Thank you, Your Honor. Okay, I've read the first paragraph as represented on page 1.
And you agree with my reading of that sentence there, starting with the word however at the time of this filing on roughly 5 lines from the end of that paragraph?
I do agree that has been read, and that is what is in the statement on this page.
And if you could look at page 3, this is the 2023 report, and you can read that to yourself. It states the same language. The Public Service reports in 2023 that it has no EDR customers taking service under a standard or non-standard EDR contract, right?
Again, I'll ask for time to review this paragraph. Okay, I've completed the review.
Okay. So it's your understanding, as you said here today, that Public Service currently has no EDR customers under a standard or non-standard EDR contract. Is that right?
As stated in the last 3 sentences of the document.
And would you agree this is Public Service's first application for approval of a non-standard EDR contract?
I agree with that.
Okay, if we could go back to hearing exhibit 204. And at page 14, starting at paragraph 48. And continuing through page 17 at paragraph 58. Here the commission talks about the settlement agreement that is the result of the 2020 EDR case. And if you want to take a moment and look at this, I understand.
Can you clarify what you would like me to?
Well, do you agree? Sure, I'd be happy to. Do you agree the commission's discussion of the settlement agreement pertains to the standard EDR contract? As discussed in paragraphs 48 to 58.
I would note under that settlement agreement for number 3, but also to note that it is the matter, the settlement was based on the matter of the settlement and approval of an economic development rate for the state of Colorado. This is the settlement agreement defined in this section, as I read it, is solely based on the standard EDR. And I believe, as previously stated, there is a section outlined of how to handle the non-standard EDR agreement as defined in the matter of the proceeding.
So if I understand what you just said, you're indicating this concerns this decision and the discussion of the settlement it pertains to a standard EDR agreement, right?
Actually, my statement, it pertains to both. The document you're referencing contains to both of the agreements. related to how to handle a non-standard and how to handle a standard under the heading of approval and a motion, the matter of an application of a motion of an economic development rate for the state of Colorado.
Okay. If we could turn to page 34 of this document, that is the first page of the unopposed partial settlement agreement. And I'd like you to focus particularly on the table of contents here. And section 2 is the standard EDR contract procedures, right?
Yes, as defined in the table of contents, looks like page 3.
Yep. And the table of contents indicates section 3 is the non-standard EDR procedures. Is that right?
That is accurate as displayed on this page.
We could turn to page 39, which is, let's see the header, section 3, non-standard EDR contract procedures. See that?
I do, thank you.
And if you'll note, if Ms. Frederico could scroll down just a touch onto page 7, you will see that now moving back to page 6 or page 39, sorry, the non-standard EDR contract procedures are discussed in the settlement agreement in a total of 3 paragraphs, right?
Thank you for that. Yes, under Roman numeral 3.
Yep. And if we could refer to the first paragraph in section 3 of the non-standard EDR contract procedures, the settlement agreement acknowledges that subject to commission approval, a non-standard EDR contract may contain terms, conditions, and or rates different from those contained in the EDR tariff, correct?
Yes, as defined in the first paragraph.
And attachment TLB-1C, and I don't need you to go to that document at the moment, Ms. Frederico, but attachment TLB-1C to your direct testimony, which is Exhibit 101, that's a confidential copy of the non-standard EDR contract, which was negotiated by by Public Service and QTS, correct?
I would like to see the document to confirm that.
Counsel, can we perhaps stipulate to whether he's identified the document? I mean, I don't think we need to have the witness verify you marked the document for identification.
Your Honor, my concern is it's a confidential attachment.
Right. No, I was asking Ms. Shields. I'm sorry, Ms. Shields. Can we not agree whether or not TLB-1C attachment to 101 hearing exhibit is in fact the signed agreement?
I apologize. I'm only having a hard time following what document we're specifically referencing.
Well, did you pre-file attachment TLB-1C to hearing exhibit 101?
Yes, sir.
Okay. And can you stipulate that it is? Let me see something momentarily.
To clarify, so hearing exhibit 101, confidential attachment TLB-1C, that is the economic development rate electric service agreement, the confidential version of that contract. Is that correct?
That was where I was going, but it is not a signed document, Mr. Bunker, if that was your question or where you were going.
No, I wasn't going to that, Your Honor. What I was just trying to establish is that is in talking about the non-standard EDR contract in reference to the settlement agreement that we were just looking at here in the first paragraph, that attachment TLB 1C is that agreement.
Okay. Can you, I'm not saying you need to, but can you agree to that, Ms. Shields, so we can keep going in a public session?
Yes, I can agree to that.
There you go, Mr. Bunker. Let's get to a question.
Okay, thank you. Let's go to UCA's box account and exhibit 205. And I'll represent, Your Honor, to you and to the witness and parties. This hearing exhibit 205 is a 22-page document, and the first 4 pages are the advice letter, and then pages 5 through 22 contain the EDR tariff.
Would you mind maybe scrolling down to the end just so we can see who signed this? And if I recall, it includes both the EDR tariff as well as adjustments to the company's electric commodity adjustment tariff to implement the EDR ECA.
Is this far enough, or do you need me to go to the very end? You said signatures, so I wasn't sure how far I needed to go.
I think just the advice letter was what I wanted to look at.
So is this correct, or keep scrolling?
Let's keep scrolling to the end while we're at it. Thank you.
And Your Honor, I would request admission by administrative notice of this document.
I'm struggling a little bit with this one. This does not appear to be a file stamp copy of something on file with the commission. If it is the tariff in effect, and was not suspended, we can get there.
Your Honor, if we can turn to page 5, which is the first page of the tariff filing, you'll see it's a PUC e-filing system document. And I would note that appears on the first page, just like on the advice letter. If we go back to the first page of the entire exhibit, I see Colorado PUC e-filing system. So that's where this was downloaded from. And it's that legend on the side, left side, for the e-filing system only appears on the first page of each of the 2 documents.
Thank you. Okay, so we actually have a combination of 2 documents presented here in Exhibit 205, being the advice letter 1858 Electric, a public service company of Colorado. And if we can go to the first, after the advice letter again, the proposed tariff pages, I guess.
Yeah, it starts on page 5, Your Honor, if it's helpful.
Yeah, well, but the proposed tariff modifications, and you're saying that this is all one document from here to the end of the document.
Correct.
Okay, Ms. Shields, how you feel about that? Any objection?
As far as administrative notice, no objection. Again, I would note that there's been no foundation laid with this witness on this particular filing.
Okay, I'll admit Exhibit 205 by administrative notice being a copy of the documents on file in the Commission's e-filing system. Mr. Bunker, do you know what proceeding number those came out of?
Yes, it is a result of, as we go back to the top, the tariff, or the advice letter. This is a result of proceeding, you'll see in about the 5th line of the first paragraph. This is a filing, a compliance filing essentially in proceeding 20A-0345E,
Yeah, but
the
it should have been,
company's EDR proceeding.
it should have been filed in its own proceeding though.
That I am not able to clarify.
Bear with me just a moment. Okay, for clarification, I am taking administrative notice of 2 filings from proceeding number 21AL0350E. That being advice letter number 1858 and portions of Colorado PUC number 8. And that tariff went into effect by operation of law. So it's actually a tariff and can be admitted on that basis alone, as to the tariff itself. Okay, so Exhibit 205 is admitted. Mr. Bunker.
Okay, thank you, Your Honor. And if we could turn to page 7 of this document, hearing Exhibit 205. You'll see at the top of the box of language there. This is the economic development rate schedule for EDR, or let me restate that. Economic development rate schedule EDR. Is that correct?
Yes, that is accurate.
And in the second paragraph of the tariff here on sheet, and this is marked sheet 82 at the top of the page. In that second paragraph under availability, the tariff states all other EDR customer service agreements, including those meeting the requirements for standard EDR contracts that would cause the company to serve load in excess of the enrollment cap applicable to standard EDR contracts, are subject to commission approval. Do you see that?
And I would ask for time to read these paragraphs as referenced in the question.
I am.
Well,
yes.
let me just jump in here. The tariff speaks for itself. It says what it says. If you want to ask the witness a question about it, then we can find out if this is something he knows anything about.
Okay, I'll move on from that question, Your Honor. Consistent with the settlement agreement, well, let me ask you, are you familiar with the EDR tariff?
I am.
Okay. So consistent with the settlement agreement, do you agree the EDR tariff indicates a non-standard EDR contract may contain terms, conditions, and/or rates that are different from those stated in the EDR tariff?
Yes, that is accurate as outlined in the statute and in the settlement.
Are you familiar with whether it is consistent with the tariff, though?
Yes.
Thank you.
And in this particular case, QTS and Public Service did negotiate terms, conditions, and rates in the non-standard EDR agreement that differ from the terms, conditions, and rates in the Public Service EDR tariff, right?
That is accurate.
And if we could turn to page 8, which is referenced as sheet 82A at the top there of the page. Underneath this table, on the top of page 8, which is the base rate discounts for standard EDR contracts, in that paragraph just below that table, the tariffs indicates the company and customer may mutually agree on a base rate discount that differs from the base rate discount table listed above, subject to commission approval of the non-standard EDR customer service agreement. Do you see that? The last sentence of that paragraph under the table?
Yes, I do. That's accurate.
Okay. And in this case, Public Service and QTS did negotiate a different base rate discount than what's contained in this table. Is that right?
That is accurate.
Okay, if we could turn back to the settlement agreement, which was hearing exhibit 204. And if we could go to page 52 of 57.
Sorry, I just want to make sure I heard you. Did you say 52?
Yes, page 52. And referring to the general provisions and that first paragraph. The agreement provides, starting at the middle of that first sentence in paragraph 1, the first sentence, nothing in the settlement agreement is intended to have precedential effect or bind the settling parties with respect to positions they may take in any other proceeding regarding any of the issues addressed in this settlement agreement. Did I read that correctly?
Yes, in the first sentence.
Okay, thank you. Okay, if we could go back to your rebuttal testimony. That's hearing exhibit 105. And on page 8, starting at line 5 through 24, and in particular, you indicate that Public Service, and this is on primarily on lines 9 through 12, and that is, you indicate after reviewing UCA's and staff's answer testimonies, Piesco is making adjustments to the company's marginal cost calculations in the company's rebuttal case. Is that right?
Yes, as stated on line 12.
And these adjustments to the marginal cost calculations, you summarize those adjustments in the 5 bullet points on page 8 at lines 13 to 24. Is that right?
Yes.
Mr. Bunker, I'm sensing a shift in topic here a little bit, and it's a 10:45. We haven't taken a morning break. Is this a good time?
Excellent time, Your Honor.
Okay, why don't we take a 10-minute break? We'll come back at 5 to the hour. We'll be in recess. I will remind folks that this is being webcast, so please mute your microphones and turn off your video if you wish. Hey, Tracy, are you back with me?
Yes, I am, Judge.
Thank you. Okay, we'll go back on the record after our break. Mr. Bunker, Mr. Bailey's on the stand.
Your Honor, we need just one more minute.
Hey, Mr. Bunker, we're ready when you are.
All right, thank you, Your Honor.
Your Honor,
Just-
if we could have
Go
one
on.
more minute, please. I'm sorry.
No problem. Okay. I didn't realize who was talking to me there. Thank you. We need one more moment.
Judge, if it's okay, before we start, Mr. Bunker, was the last exhibit you were on still 105, page 8? Got a lot of tabs open, so I just want to make sure I'm on the right one. Okay, thank you.
Yes. 105 at page 8. Excuse me.
And are we ready, Ms. Shields?
Yes.
Okay.
Apologies.
I think it was from your computer somebody spoke. I'm still not sure who
Oh.
told me that. Somebody asked for another minute. Are we ready, whoever you were?
Yes,
Mr.
public service is
Eisenberg,
ready.
perhaps? Okay, thank you. Mr. Bunker.
Thank you, Your Honor. And Mr. Bailey, just to reset, on page 8, I think my last question to you was the 5 bullet points on page 8 at lines 13 and 24. This summarizes the marginal cost calculations or the adjustments to the marginal cost calculations. Is that right, in the rebuttal testimony?
Yes, as identified, lines 13 through 24 in your question.
Okay. And sorry, my jumbled question, my jumbled repeat question. Thank you. New question now, moving forward. Is it your understanding, Mr. Bailey, that the adjustments to the company's marginal cost calculations in the rebuttal case change or otherwise modify the marginal cost calculations in Mr. Wishart's direct testimony and attachments in such a way that the judge and the parties should essentially disregard the direct testimony of Mr. Wishart on those topics?
I will push that question or have that question if possible answered by Mr. Rurup. What I will respond with is I think these modifications are our next assumptions or expectations as the rate construct potentially could have changed with these filings. But Mr. Rurup can go into more detail with that question.
Okay. Thank you for that. I appreciate that. And do you feel you're able to generally answer a question or so on each of these bullet points, or should I wait to discuss that with Mr. Rurup and just refer to your testimony when I do?
Yes, I would refer to my testimony and Mr. Rurup specifically on the rates. I would, just expand a little bit on your question. We obviously will continue to have the burden of proof to ensure that the marginal cost calculations are above and that there's no subsidies to other customers.
Okay. Well, let me ask you a couple of questions about these bullet points, and if you can answer them, great. And if not, we'll take it up with Mr. Ruup. And did I pronounce that right? Ruup?
Rurup. Yes.
Thank you. Looking at this first bullet point, and that is updating the generation resource information based on the recent generation bids submitted in the phase 2 2001 ERP and CEP case. Is that bullet point reference to public services acceptance of UCA witness Mr. Neal's recommendation that the marginal cost of capacity should be modeled off bid data from the company's 2021 ERP case?
Objection, that goes beyond the scope of Mr. Bailey's testimony. Mr. Rurup is the appropriate witness who addresses these in detail. And Mr. Bailey at line 25 even cites to Mr. Rurup as the appropriate witness.
And Your Honor, I agree with what, to some extent, what Ms. Shields just stated, but I asked him if he was able to perhaps answer some questions, and if not, to defer to Mr. Ruup. And if he needs to defer that question, I understand.
Well, he can answer the question if he knows the response, but I do think Mr. Rurup's testimony does go into this quite detail, and this is really just saying what those adjustments are. So hopefully we can be pretty narrow and keep us moving along here, but I'll allow him to answer the question. Do you know is the first bullet point in response to the recommendation of Mr. Neal?
I do not know, and I would ask to have that question to Mr. Rurup.
Thank
you. Okay, very good. And I will skip a handful of other questions on the other bullet points as well. Let's move to your direct testimony, which is hearing exhibit 101, and the attachment TLB2. And this is the copy of the transmission facilities construction service agreement between PSCO and QTS in this case, right?
That is obviously not seeing the signature, but yes, that is.
And if we could move to section or page 2 of that document. And this is the 5th paragraph and what I will call the preamble language above section 1 and definitions there at towards the bottom of the page. So the paragraph that starts contemporaneously with, do you see that? And could we scroll down on the document just a little?
Thank you. Yes, I see that 5th paragraph.
Okay. And you see the last sentence in that paragraph that says, company will provide retail electric services to customers' data center at a discounted rate, and should regulatory approval not be received, the customer nonetheless desires to obtain electric service from the company will provide electric service to customer pursuant to the rates, terms, and conditions set forth in its electric tariff. Did I read that correctly?
Yes.
And if we could look at the bottom of the page there, under definitions, you'll see additional transmission facilities. And here the contract defines additional transmission facilities as two approximately 1.4 mile long 230 kV transmission lines, a new 230 kV switching station, substation communications equipment, and remote end upgrades of two existing transmission substations to be owned and operated by the company in connection with provision of electric service to the customer. Is that right?
Yes, that is accurate.
So the construction project under this agreement is for a transmission line that is designed as a double 230 kV circuit loop that will serve a dedicated single customer, and it will terminate at the commission or at the customer owned substation. Is that right?
That is as I'm aware of. Again, I'm not an engineer, and if there's a detailed question, I would place that to witness Rozak.
Okay, and if we could turn to page 6 in paragraph 4.2.1 at the bottom of the page. Here the parties estimate the amount due to be 28.1 million, which the customer will pay in the form of a stage 1 payment and a stage 2 payment per exhibit F. Is that right?
That is accurate, and we've collected a little bit over $10 million dollars from the customer, and we'll collect the second, I guess, the stage 2 payment in the spring of 2024.
Okay, and if we could turn that to that schedule F, it is page 29. And here you see the schedule of payments, and that indicates stage 1 payment of $9,475 was due June 21st, 2023. And down towards the bottom of the page, the stage 2 payment of $18.1 million is due April 4, 2024. Do you see that?
Yes, I do.
And so is it your understanding QTS will not have another payment obligation under this transmission construction agreement on the $28.1 million project until April of 2024?
Yes, as defined in this agreement.
And if you look at the language there, just under the payment amount of 18.1 million for stage 2, it indicates that the $18.1 million due in April of 2024 is for material procurement and for the construction stages of the project. Is that right?
I can only see down to the subset B on my screen. If that can be moved.
I'm sorry, I didn't. Oh, there we go.
There we go. Thank you.
Sorry about that. I'm looking at a separate screen and I didn't notice that. Sorry.
No, that is just fine. Thank you. Could you restate your question? I apologize.
Sure. Is it your understanding that the payment to stage 2 payment rather in the amount of $18.1 million that is due in April of 2024 is for material procurement and for the construction stages of the project?
Yes, as defined in this document.
And is it your understanding that this amount, this $18.1 million for stage 2, is not secured by a security fund such as a letter of credit or an escrow account?
Could you restate that? I'm sorry.
Sure. Is it your understanding that this stage 2 payment amount of $18.1 million is not secured by a security fund such as a letter of credit or an escrow account?
Yes, that's accurate, provided that internally our security team went through our process and risk team went through our process to review the customer and provided the appropriate assurances of future payments through Excel's process.
Okay, thank you. Your Honor, a procedural question, and that concludes my public cross-examination, but I do have a handful of questions that concern the confidential EDR agreement, which is Mr. Bailey's attachment TLB1. And so my question to Your Honor is, do you want to go into confidential session to address that now? Or would you rather wait until others ask public questions and then we go to confidential session?
Yeah, I think, or maybe even a third choice, but well, let's hold the questions for the moment. Approximately how long would you anticipate? I mean, it's like 5 or 10 minutes or?
About 10 minutes, I think, Your Honor.
Okay. Okay, let's just keep a pin there. You're not done with your cross, and we'll come back to you for the confidential cross, and we'll decide when we get to that point. We may do it right before lunch is what I'm thinking. But we'll see where we get to.
Okay, thank you, Your Honor.
Okay. Then we are to Mr. Rushoff.
Yes, good morning. And CEC actually is going to waive its cross on Mr. Bailey.
Okay, thank you. And I believe we see, it's 11:12. I guess, Ms. Shields, why don't we do the redirect on the public portion, and then we'll do confidential, then we'll take our lunch break.
Sure thing. All right. Mr. Bailey. Oh, and Your Honor, do you have any questions for the witness?
You know, I do. I'm sorry, I have one. Ms. Bailey, you do characterize the positions of OCC and staff in relation to the settlement. And I'm not asking your legal opinion, but I'm asking is it your understanding or your position that either staff or the UCA are in violation of the settlement agreement in proceeding number 23A-0330E?
I am not in a position that they're in violation, Your Honor.
Okay, thank you. That was my only question. And checking. Yeah, so Ms. Shields.
Your Honor. Mr. Bailey, I have a couple questions for you, and we'll work in reverse order. We can try to do this without bringing it up on the stand. You just had a couple of questions with Mr. Bunker about an $18 million stage 2 payment. Do you recall that?
Yes.
And do you recall when you were looking at the screen that being due on April 4th, 2024?
Yes.
And is it your understanding that the commission deadline for a decision in this case is on or about March 27th, 2024?
Yes, I am.
Thank you. Next, I'd like to go back. You had a long series of questions, particularly with Mr. Bunker, around the applicability of the settlement agreement and the commission's decision that was approved and issued in 23A-0330E. Do you remember that exchange?
Yes, I do.
And throughout the course of that exchange, you received quite a number of questions surrounding the applicability of the settlement agreement to non-standard EDR applications, correct?
Yes, that is accurate.
And to your knowledge, no one in this case, including the company, disputes that this application is for a non-standard EDR, right?
Yes, that is accurate.
So regardless of whether or not the settlement for standard EDRs, whether those provisions apply to this non-standard EDR, you would agree that the EDR statute applies to this non-standard EDR agreement, correct?
That is accurate.
Okay. And would you agree that by the company conforming in large part this non-standard EDR ESA to the settlement agreement, that it has gone above and beyond the requirements of House Bill 181271?
Your Honor, I'm going to object to that question. Number one, it was leading, and number two, it's a legal assertion that they've largely complied with, conformed with the statute, and so that's a decision that you're gonna have to make.
Perhaps you can rephrase, counsel.
Sure. Mr. Bailey, is it your position, your opinion, that the company has complied with the provisions of House Bill 181271?
Yes, it is.
For this non-standard EDR, correct?
Yes, for the non-standard EDR contract with QTS.
Okay. You had a couple of questions. You had some dialogue with staff counsel, specifically regarding data centers. And do you have any reason to believe the legislature intended to disqualify data centers from eligibility under an economic development rate?
I do not have that position, and I would expand to the fact that the legislature identified that it cannot be discriminatory to any industry provided they meet the provisions of the statute and the utility has executed the proper burden of proof for the requirements on a filing and a marginal cost test.
And I think at one point you started talking about some of the overall economic benefits and impacts from data centers. Could you elaborate on that?
I can, and really on the basis of job creation, and I believe witness Wright will discuss this in more detail, but overall you think about the agreement and strategy of QTS displaying in their testimony over $1 billion of capital investment in Aurora. You're going to have 1,500 construction jobs in the first 2 years. Jobs, when you think about the creation of the indirect and the induced, it's going to be a large multiplier effect, not only for Aurora, but for Denver and the state of Colorado. So this capital investment is going to be great for the state and the overall economic impact for tax base and for job creation, not only at the data center, but throughout the communities where it will locate.
So in your opinion, will this facility expand opportunities for employment in Colorado?
Yes, it absolutely will.
Mr. Bunker from UCA asked you a question or two. He pointed to some testimony from UCA that alleging that data centers are not a good fit for the economic development rate. Do you recall that?
Yes, I do.
Okay. Could you explain whether or not you think data centers are or are not a good fit for economic development in Colorado?
I do. I think they're a very good fit, and to the point, I think the action taken by the legislature to pass a statute like this that increases the competitive nature of the state of Colorado is extremely profound. We deal as in the state for the benefit of how do we create value. We're competing against Western states, Wyoming, Idaho, Utah, Nevada. We want those jobs here. We want that investment in the state of Colorado. And so I think it's very important for data centers and future industries who participate in this program. It will elevate the economic activity here, which is a great thing for everyone.
And have there been any recent developments here in Colorado demonstrating the state's interest in attracting data centers to the state?
We've got letters of support from the governor's office and from certainly the city of Aurora, but also we partner Excel and our teams with local and state agencies of going out and attraction and being very deliberate about the attraction and making sure it's the right fit for the state of Colorado.
And if we could please pull up hearing exhibit 151 from the company's box.com account. And Mr. Bailey, have you seen this article before? This is a recent article from the Denver Post.
I have seen this, yes.
And can you give me a summary of kind of the headline and what's in this article?
I can, and this is coming out of successful.
Your Honor, I think I would object. This hasn't been admitted into evidence yet, so testifying as to what it talks about, I think at this stage is improper, and I would object to its admission because it's hearsay and on that basis alone.
Well, hadn't been offered for admission. I agree with that part, so I'll sustain the objection. And Ms. Shields, you can lay your foundation, move it if you wish, or ask the question to the witness about his knowledge.
Well, okay, all right. Well, I'll ask the question again. Mr. Bailey, are you familiar? Have you seen this article? Are you familiar with the content of this article?
I am familiar with the content of this article and the larger macro work that we do not only in Colorado but throughout our territories following the CHIPS Act. This is exciting. I'm actually on the board of directors for the Colorado Clean Tech Industries Association, which has.
Again, Your Honor, I object. His answer is going beyond the scope of the question. If he was familiar with this article,
I'll allow the answer. I think he's telling you why his familiarity with the article.
Yeah, thank you, Your Honor. Not only familiar, but I think importantly, having leaders in our state who are going to enact this. So this type of tech hub is very important to the economic foundation of semiconductors, AI, and data centers in general. It's exciting. It'll be something that Governor Polis has obviously supported, and we will be part of the solutions and leadership as this expands in the state and for the overall hub.
With that, I'd like to move for the admission of this article. And in doing so, I will point out that staff witness Ms. Segala, for instance, has submitted attachments that include articles or publications from third parties that she has not authored or sponsored. There's a Cushman and Wakefield report regarding data centers. It's been attached to her testimony. So feel it's appropriate that we have the opportunity to respond to the general marketplace surrounding data centers and the state's interest in retaining and attracting them.
The objection to the admission of Exhibit 151.
Yeah, Your Honor, I do object to that. And also, Ms. Shields refers to Ms. Segala's testimony and said, asking for the opportunity to respond. The public service did have the opportunity to respond in the rebuttal testimony. And so to put this in on redirect, so I think it's improper on that basis as well. So I do object to it.
Ms. Federico, would you scroll through the document, please? I'm gonna sustain the objection. The document's not dated, and even if he's familiar with the article, it is clearly hearsay as to the truth of the matter. So I'll sustain the objection.
Sure. Mr. Bailey, we'll go down a different way. Could you tell us a little bit about recent developments and political support for attracting data centers here to Colorado?
Yes, we have worked with state and federal legislators on kind of that next generation of technology advancement. Colorado has always been, in my opinion, form of a tech hub. Even when I did not live or work here, you're thinking about aerospace and the advancement of technology is very, very important. This is the next step of new technologies, semiconductor, AI, data centers, and it's very important for the competitive nature of the region to maintain their differentiation. So it's a great step. We obviously have to go through the process as a region on how to allocate the funds and govern the funds, but it is an exciting first step. Has been stated not only publicly, but in several meetings that I have attended.
And is the QTS data center aligned with Colorado's recent designation as a tech hub?
It is.
I'd like to go back to a couple of questions earlier in the cross-examination that you had with Staff Counsel, Mr. Opp. You recall a discussion with him around QTS's, that they will be a master meter operator.
Yes.
Is this common for data centers?
It can be, depending on their business plan.
Mm-hmm. And you've been working with data centers for quite some time throughout your career, is that correct?
Yes, I have.
Do you have any reason personally to believe that QTS will resell electricity to its tenants at a higher price than it pays public service?
No, I do not.
Under the EDR ESA, who will be public service's customer?
QTS will be our customer.
Right. And is QTS and QTS alone the counterparty to the EDR ESA and the transmission services agreement with public service?
Yes, that is accurate.
And QTS is committed to delivering load to public services system, correct?
Yes.
And so QTS and QTS alone is the party that will bear the risk under the contract with public service, correct?
Not only the risk, but the required bill payments.
I think Those are all the questions on redirect that I have for you, Mr. Bailey.
Thank you.
Okay, we're a little earlier than I thought we might be, but what I think we'll do is go ahead and we will in a moment go into a confidential session, then take our lunch break, and we'll return after lunch. We'll say 1 o'clock. I'm sorry, let's say 12:45. We'll keep us moving. 12:45, and so that anyone in the public can rejoin us after the lunch break. And with that, Ms. Federico, if you would stop the live streaming.
Yes, while I'm doing that, Ms. Shields or someone whose confidential information it is, can you let me know if anyone in the Zoom meeting here is not allowed to be here?
And we would get, we'll get there. Yeah. So yes, that's it. It's public. First off, I'll ask any participants in the meeting, if you've not signed the appropriate NDA, Hey, Tracy, are you with us? Or Harriet? Well, Harriet.
Harriet. It's Harriet.
Thank you. All right, you ready to go, Harriet?
Having a problem with my mute button. Yes, I am.
Thank you. All right, we'll go back on the record after our lunch break. Ms. Shields, call your next witness.
Yes, Public Service would like to call to the stand Mr. Travis Wright.
Thank you. And Mr. Wright. Oops. There we are. Okay, Mr. Wright, if you would please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Ms. Shields.
And good afternoon, Mr. Wright. If you could please state your name and title for the record.
Of course. My name is Travis Wright. I'm the Vice President of Energy and Sustainability for QTS Data Centers.
And you are the same Travis Wright who submitted direct and rebuttal testimony in this proceeding, correct?
I am.
And if I were to ask you those same questions today, would your answers be the same?
It's one minor change. So we have updated the site plan. The original testimony talked about 4 buildings on the site. The rebuttal testimony actually referred to 3, and 3 buildings is what we're planning to build on the site. The ask for utility power remains the same. It's just different sizes of buildings.
Thank you for that clarification. His testimony, I believe, has already been admitted into the record. And with that, I would like to make the witness available for cross-examination.
Thank you. Mr. Valentine, any cross or clarification, really?
No, Your Honor.
Thank you. And then Mr. Ott.
Thank you, Your Honor. This is a preliminary matter. I will have a line of questions that refer to confidential information. And so, you know, at the outset, I don't know if UCA does that, but I just want to see if it might make sense for me to hold off and we just group those together if that's what they have as well.
I think we will group them together, whether they have additional ones. Ms. Crampton, you want to let us know?
Yeah, thank you. I don't believe I have any questions that dive into confidential information.
Okay.
Okay.
I'm still inclined, maybe we can wait till the end of the day to do a confidential session.
Yeah, I'm fine with that. I just wanted to let you know that, and it's just a specific discrete line of questions.
Thank you. Okay.
Good afternoon, Mr. Wright. How are you?
I'm well, thanks. How about yourself, Mr. Opp?
I'm good. And so we haven't met, but I'm Kevin Opp. I represent trial staff in this matter. And so I just want to go through some questions with you. And so, you know, you talk quite a bit in your both your direct and rebuttal testimony about the statutory requirements on the EDR statute. And so so you're familiar with that statute, correct?
Peripherally, yes.
Okay. Well, you know, why don't we turn to hearing exhibit 300 and go to page 11 so we can just have this as a reference. Great, right there. And so, yep. Thank you, Ms. Federico. So I'll represent to you. This is the answer testimony of Ms. Fiona Segala, but she has a reference here to the EDR statute. So that's why I'm just pulling this up so we can, you know, look at that together. So if you could just look at line 8 through 10, and let me know when you're ready.
Yeah, sure.
Okay, so I want to clarify So I know we talked about, so QTS is going to be the customer with public service, correct?
Correct.
And the load associated with that is going to be, is coming from the majority of, well, the vast majority of that load will be coming to use to serve the various tenants within the QTS data center.
The majority of the load in the building will be used to power equipment that is owned by the customers, yes.
Okay. And so do you have an idea of how much of this load that QTS will need for its own specific purposes, and that's not associated with, or that's not being passed on to the, what you just said, the equipment of the various tenants?
Well, keep in mind that we don't pass on the power. We buy the power. We are the customer of public service. We pay the bill, and we allocate a portion of what we spend on that electricity by measuring how much electricity our customers use, and we proportionally allocate that to our customers.
Okay, can you come back and answer my question, which was of the power, the electricity that QTS is purchasing? Do you have an idea of how much of that it relates to QTS's own purposes and not related to the tenants?
I would probably say 100%, because we are running the facility.
So let's see if we can agree on a couple things. So you're saying that right, you talked about the energy being used that's allocated by the tenant's equipment. Remember that?
I do.
Okay. Do you have a sense of how much of that, how much of QTS's load it relates to those tenants, serving those tenants' equipment?
It's a complicated question, because the equipment that they use specifically for IT, their servers, I guess storage arrays, things like that, it is one number. You've got everything from lighting and cooling and maintenance corridors. It's a very complicated question. What I will say is that if my customer fails to pay their bill, I am still responsible to pay my bill to Piesco.
You know, Mr. Right, it would be really helpful if you just focused on my question and then answer that. Ms. Shields will have the opportunity to come back with you, because you're not answering my question. You're avoiding it. My question is fairly simple. Would you say that the majority of use is being used to serve these tenants, the equipment that they have?
The majority of the power that's used within the facility is used to power servers and storage arrays that our customers use. Yes.
That your customer, and you know, maybe so we can have the record clear. Why can we refer to what QTS's customers are? Can we refer to them as tenants? And say, and so and then QTS is the customer of public service, just so you know it doesn't muddle up the record. I just want to make sure we're on the same page.
I might prefer that we use IT equipment.
I'm asking you if we can do it for my series of questions. Can you do that for me on my series of questions?
Sure.
Okay, thanks. So would QTS qualify for the QTS? So the load, getting the load that it's anticipating is dependent upon QTS having tenants use at QTS's facility, correct?
Yes, probably.
Well, why do you say probably?
Well, we're anticipating 160 megawatts of load at the site. Usually, generally speaking, we use an efficiency factor, it's called PUE, of 1.3 to 1.4, which means that about 30 to 40% of the load in the site is used for cooling. And that's something that is under QTS control. So 3 megawatts is a very small number. I mean, you can almost get to 3 megawatts without customers in the entire site, but it'd be close, probably be close with 0 customers in the site.
Okay, well, let's talk about that cooling that's being used to serve the customers. Is QTS, is that how's QTS going to allocate those costs? Are you gonna allocate it to the tenants?
Yes, we will. Yes.
Okay. Now, it's my understanding that QTS does not have any tenants yet.
Correct.
Okay. So right now, there's no restriction on tenants being allowed to transfer existing load from the service territory of one utility into public service so they could be tenants for QTS.
Well, since we have no customers, I would say yes.
Okay, but prospectively, you haven't put that in there.
Sorry, could you repeat the question?
You know what? Never mind. You answer the question. I'll move on.
Okay.
So, there's nothing in, and then also prospective tenants won't be required to demonstrate that the cost of electricity is a critical consideration when deciding where to locate or expand, to locate new or to expand existing operations, correct?
Sorry, again, I didn't quite follow the question.
So similar, QTS is not right now, is not requiring the tenants, any prospective tenants, to demonstrate to QTS that the cost of electricity is a critical consideration in their decision to come and be a tenant for QTS, correct?
Well, so the way the business works is tenants will have a need for data center space, and they will provide us with what's referred to as a request for proposal. And in the request for proposal, there might be 50 or 60 different questions on how we run the business and what the costs are for certain line items. One of those line items is virtually always, what is the historical price of electricity? And so it comes up in every conversation that we have with our customers about coming into a facility, but there's nothing that we ever dictate to our customers.
Okay, thank you.
Does that answer your question?
Yeah, you did. I appreciate that. Thank you. So we can drop this reference on this hearing exhibit, and if we could turn, excuse me, to your rebuttal testimony, and that is exhibit 108. Let's turn to page 14. So I just want to be clear on this, that if the commission denies the application, QTS will still build the facility, correct?
Yeah, so currently we are under construction with the first of 3 buildings. Moving to the next phase means that we do what's called fit out. And so we build the shell of the building, which is the walls and ceiling, and get the thing dried in and ready to go. We bring utilities to it. We get it to a point where it is ready to get equipment. And so as we start selling space within the facility, we fit it out with the UPS systems and the batteries and the electrical gear and the generators and the cooling systems. All of that equipment starts to go in. So we are absolutely going to finish the shell. And as soon as we assign customers to the building, then we'll start fitting it out.
Okay. And that's regardless of whether the application is approved or not.
That's true. Yeah.
Thank you. All right. Let's turn to page 7. And you can refer to line 5 through 8. Take a look at that and let me know when you're ready.
Okay.
Okay. Now, I just want to be, understand it's not your contention or that because the Aurora campus, this decision of Aurora contributing, supporting the project, you're not saying that's a deciding factor, that the statute, that's a deciding factor for the application being approved or not being approved?
While they're not connected, I do think that the city of Aurora went through a very comprehensive process to determine whether or not it would be in the public's best interest to put a data center here. And their affirmative, I think, should add credibility to the fact that it does.
Right, but that's not a factor under the statute. You'd agree with me. You'd agree with me on that.
I honestly am not an expert in the statute, but
Okay.
I believe.
Okay. All right. Let's turn to page 9. And then let's go to lines 14 through 16. And just familiarize yourself with the sentence that begins with the 10-year discount, and then let me know when you're ready.
Sure.
Okay. So as I understand this, if the application is approved and QTS gets the discount, and meaning that the cost of electricity that QTS has to pay to public service, that'll mean that among the costs that it allocates to its tenants, that discount will be reflected in the amount charged that QTS charges its tenants, correct?
So they're two different line items. There is a negotiated rate that we have for our space. So it's the capacity within the building. So the square footage and the cooling systems and the electrical systems is one line item, and then a pass-through charge of whatever it is that we're paying for electricity, 100% pass-through to our clients.
Okay. That's all I have on the public portion, and I guess I'll talk to you later this afternoon.
Okay.
Thank you.
Okay, Mr. Bunker.
And thank you, Your Honor. I actually have some questions for Mr. Wright on behalf of UCA.
Thank you, Ms. Crampton.
And hello, good afternoon, Mr. Wright.
Good afternoon, Ms. Crampton.
My name is Kate Crampton. I'm an attorney representing the UCA. I have some additional questions to follow up on some of Mr. Opp's questions, as well as your pre-filed testimony in this case, okay?
Yes, ma'am.
And just by way of some background, Mr. Opp had given you some questions about your rebuttal testimony. And in your rebuttal testimony, you reference and sort of respond to some issues raised both by trial staff and by UCA witnesses. Is that right?
Perhaps I'd probably need to see the specifics of what you're asking though.
Sure. Let me ask a different way. Generally speaking, in drafting your rebuttal testimony, you had an opportunity to review the answer testimony of some of the intervener parties in this case.
Yes.
Okay. And some of the questions that Mr. Opp was asking you about came up sort of in the answer testimony provided by the interveners, and specifically about the business of QTS's future tenants. Is that right?
Again, I would ask you to point specifically to what you're asking for.
Okay. Well, let me ask you this. Is it fair to say that the business of QTS's tenants, potential future tenants, was of concern to the parties in this case?
Yeah, I do recall that there were questions about who our future tenants would be, but if that's what you're asking.
Sure, yes. And specifically during the course of this proceeding, a question that sort of came up repeatedly was the question of whether QTS itself or its tenants might be engaged in the business of cryptocurrency mining. Is that right?
I recall that. Yes, I do.
Okay. And in asking these questions, the intervening parties were curious about the types of activities that would occur at this QTS facility as well as other existing QTS facilities. Does that sound familiar?
It does.
Okay. And you recall that these questions also came up or were posed not only in the parties' answer testimony, but in the discovery process.
Sure.
Okay. And in providing QTS's responses or responses on behalf of QTS, you indicated that QTS itself is not engaged in the business of cryptocurrency mining.
Correct.
However, as you testify here today, you cannot definitively state whether or not any QTS customers engage in the business of cryptocurrency mining.
Objection. I'm failing to see the relevance of this line of questioning. The EDR statute says nothing about cryptocurrency mining being a relevant factor or even anything that should be considered as part of this economic development rate. The witness has indicated that he is not familiar with any of the testimony that she's referencing. We have no testimony on the screen or discovery on the screen. So I fail to see how this is relevant.
Ms. Crampton?
Your Honor, it's relevant. It's the decision for you and the commission is not just whether the statutory elements are met, but whether approving this contract or this application is in the public interest. And in Mr. Wright's testimony, he discusses the business of QTS and how they intend to lease, or I don't know if lease is the correct term, but acquire customers of their own or tenants of their own. And so what business is actually being conducted in the QTS facility, if this application is to be approved, is certainly relevant for this court's consideration. If it's helpful to the witness, I can direct him to specific discovery questions on these topics.
Well, and I'd point the public interest standard may be the standard that governs this proceeding, but cryptocurrency has nothing to do with whether or not this project is in the public interest. And there is no statutory reference, no rule reference that has anything to do with the type of load or cryptocurrency being tied to this facility.
Well, I'm actually going to overrule the objection. I think I've allowed in some testimony thus far as to perhaps you might say the quality of the economic development. So I'll allow a little leeway here, but Ms. Crampton, this is you're getting to the edge of that relevancy. So I'm hoping we can get this nailed down and move on pretty quick.
Thank you, Your Honor. If we could, if it's helpful to you, Mr. Wright, could we pull up from UCA's box hearing exhibit 210, please? And I think if we could, it's 2 pages, so if we could maybe scroll down to the second page. And Mr. Wright, I'm showing you hearing exhibit 210. This is a discovery question from the UCA 2-11 You were the sponsor of this discovery response, correct?
Yes.
And these were
Yes, and I would like to reiterate that I have launched an objection. I understood that it was previously overruled, but point out that there was an objection on relevancy grounds that was included in this discovery response.
Okay, that's, I see, I understand that this, you're into the response, but we don't have it admitted yet. So I think we're still at foundation. Ms. Crampton.
Thank you. Mr. Ray, you testified on Mr. Opp's questions and cross-examination, and I just want to clarify. To date, QTS does not have any specific tenants locked in for this Aurora facility, correct?
Correct.
And what the tenants that QTS ultimately contracts with, what their business is something that could be relevant or could be important for this judge's determination whether to approve this application, correct?
I can't answer what the judge thinks is important or not.
Okay. You would agree with me that if a possible tenant was engaged in an illegal enterprise, that might impact a court's consideration.
I guess again, I wouldn't know the answer to that, but I would hope that we're not bringing clients on that are engaged in illegal activity.
Okay, and just to kind of back up, the nature of the business of QTS's potential tenants was a question asked to you by the intervening parties during the course of discovering this proceeding, correct?
Yes.
Okay. And I'd asked you that QTS itself does not intend to engage in cryptocurrency mining, correct?
Correct.
And if we could just scroll back down on this exhibit 210, please, or up, I'm sorry. Okay. And here, in fact, you responded that QTS does not engage in cryptocurrency mining.
Correct.
But you also indicated that you cannot definitively state whether any of QTS's tenants engage in cryptocurrency mining.
So I will admit that if we have Microsoft or Meta or Google or Oracle in our facility, we do not police what they are doing with their space. They are 100% in charge of whatever it is that they do within that space. If there is some sort of I don't know, some sort of a legal reason that we need to cooperate with authorities to change what they're doing, absolutely, we're on board with that. But we do not police what they do with their infrastructure.
Okay, and that's why you indicated in this response you cannot definitively state whether they engage in this business.
I can't. No, I mean I can tell you, I know what types of customers we bring in. We generally understand their business model and how they run their businesses, but I can't tell you definitively what they're going to do with their space.
Okay, which is why you wrote what you wrote, correct?
I believe so, yes.
Okay. Your Honor, I would move to admit hearing exhibit 210.
Any objection to the admission of exhibit 210?
Well, I would renew my previous objection as well as the objection that's included in the company's response.
Okay, the discovery objection was not brought to me. I think that this is a discovery response that this witness provided in the case. And I'll admit hearing exhibit 210 as it is presented.
Thank you. And Mr. Wright, I think you kind of alluded to this, but just to be clear, when you say that QTS does not police its tenants unless sort of directed or ordered to do so, QTS currently does not place any limitations to preclude customer tenants whose business is cryptocurrency mining, correct?
I would probably disagree with that. We have in the past allowed tenants, cryptocurrency mining. We decided it was not aligned with our business model and no longer take on clients whose specific objective is cryptocurrency mining.
Okay. You would agree that there's nothing in the EDR ESA agreement with public service that precludes a customer tenant whose business is cryptocurrency mining.
Yeah, I don't recall there being any preclusion from cryptocurrency mining.
That specific language is just not something that's included in this contract between QTS and public service.
I would agree with that. Yeah.
Okay. And if this commission approves this EDR application, then a future customer tenant who did engage in cryptocurrency mining would receive the benefit of the EDR energy rate, correct?
So you're asking me a hypothetical situation if a client that we didn't know was going to engage in cryptocurrency mining decided that they were changing their business model and decided to cryptocurrency mine, they would get the benefit of the EDR. Is that what you're asking?
Yes.
I guess in a hypothetical situation like that, the answer would be yes.
Okay. Mr. Wright, I believe you were here earlier this morning when Mr. Bailey was asked some questions about the anticipated job creation. Do you recall that line of questioning?
Yes, ma'am, I do.
Okay, I think Mr. Bailey had indicated that you might be the appropriate witness to discuss that. So I have some questions for you kind of in that vein.
Fair enough.
And in fact, this is something you wrote about in your testimony that you submitted in this proceeding, correct?
Yes, it did.
Okay. And in your testimony, you noted that QTS, if this application is approved, that QTS will theoretically employ a total of 70 to 85 full-time employees. Is that right?
Maybe misstated a little bit. That's a combination of folks who would be directly employed by QTS plus specific contractors for things like security and cleaning, and maybe there's a little bit of building maintenance that would be 100% full-time. And then our clients, when they come into the building, it's not uncommon at all that they lease office space from us as well, and they have full-time employees who are working there as IT associates. And so that 80 to, I think it was 75 to 85, it would be encompassing of all three of those categories, yes.
Okay, I appreciate that because I think you're kind of anticipating maybe my next questions and breaking this down. So of that approximately 70 to 85, QTS employees itself, QTS itself would employ approximately 25 to 30 of that total, correct?
Yeah, think of it like if a developer were to build an office building, they would, the number of people that are employed in that office building would be in the thousands, maybe. But the actual developer who then is responsible for building maintenance would only be a small handful. It's similar in nature to that. We build the infrastructure that allows tenants to come in and put very highly technical equipment inside and use our infrastructure for their benefit.
Okay. And I appreciate that hypothetical. I do think we're on the same page. But for you at QTS as the customer, we're really talking about 25 to 30 full-time employees.
Directly associated with QTS, yes. Okay.
And then the other remaining from that approximate 70 to 85, approximately 25 to 30 of those would be employees of QTS's customer tenants, right?
Yes. Yep.
And then approximately another 25 to 30 could be those customer tenants' contractors.
No, those would be our contractors. So QTS would contract the security services and the cleaning services and the general building envelope maintenance. And that would be full-time employees that come to work at that data center all the time.
Okay. If we could pull up hearing exhibit 102, please, and specifically page 11, about the middle of the page. Okay, and Mr. Wright, do you recognize this hearing exhibit 102? This is your direct testimony filed in this case, is that right?
Yes.
Okay, and what you wrote in this sworn testimony is that QTS is expected to itself employ 20 to 30 full-time employees. Right?
Yeah, I'm reading through my statement here. Hang on. Aurora.
Sure.
Yes, I do see where it says the final statement I think that you're getting at here is an approximately 20 and 25 of those contractors will be employed by those tenants at any given time. Yes, I did say that, didn't I?
Okay. And so those employees, sort of, you have your QTS employees, those jobs you anticipate being created, and we have the hypothetical customer tenants, and then their hypothetical contractors. Is that right? According to your
According to this testimony, you're right. Yes.
Okay. Now, you, in your written testimony, you don't provide any information about the types of salaries or benefits that you expect these 25 to 30 QTS employees to receive, correct?
Correct.
Okay. And likewise, you don't provide any information about the salaries or benefits that you anticipate hypothetical customer tenants would pay their employees, correct?
Correct.
And you don't know what your hypothetical customer tenants would pay any contract employees.
I mean, I didn't state any of that here. We know what we pay our employees. We know what we pay our contractors. So we have some idea as to what it would be. But I think your question is, did I state any of that here? I did not.
Okay. That's not information in your testimony.
Correct.
Okay. And QTS can't set a salary or benefit package for its customer tenant, for its customer tenants, correct?
Oh no, yeah, no, we don't set their salaries.
And likewise, if your customer tenant had a contract employee, QTS can't set that salary or benefit package.
Correct.
Okay. And this information about, kind of what these potential full-time employees, what kind of wages they would receive or what type of benefit packages they might receive could be important information because, as you note in your testimony, QTS, you believe, brings economic activity without adding significant demand for local government services, correct?
Correct.
And under the proposal for this EDR application, public service and QTS seek 10 years of economically incentivized energy rates in exchange for the creation of these approximate 70 to 85 permanent full-time jobs.
Objection. I'm sorry, I'm not sure where this is coming from. I'm not familiar with those lines in his testimony or anywhere in our application.
Ms. Crampton, could you restate that question, please?
Sure. Mr. Wright, you'd agree with me that one of the reasons you've set forth in your testimony of why the commission should approve this EDR application is the jobs that the QTS campus can be expected to create in Colorado.
Ms. Shields, do you object to that question?
Well, I'm not seeing a testimony reference to where the question comes from. So yes.
I don't think I think it was a question she just asked. It's not pointing to specific words of his testimony. So I'll overrule the objection. Ms. Crampton, if you would ask that question one more time for the witness.
Sure. Mr. Wright, you provided testimony in this case in support of QTS's application for this EDR rate, correct?
Yes.
And you gave reasons that you thought an ALJ and ultimately the commission should approve this application.
Yes.
And you wrote testimony, in fact, about those reasons.
Yes.
And one of the reasons, and we're looking at it right now on the screen, was the jobs that you expect this QTS campus to create.
That is one of the reasons, yes.
In the answer testimonies that you had a chance to review, as well as the discovery in these questions, and I think Mr. Opp got into this a little bit with you as well, there was kind of a question about the new load created by QTS. Do you recall that line of questioning?
I'm not following you. The new load, meaning the electrical load at the data center? Is that what you're asking?
Correct.
I do recall the conversation, yes.
Okay. And is it fair to say that it's your position that if this is approved, this will be a new load that QTS creates?
In the PSCO territory, is that what you're asking? This is a new electrical load that is not there today in Colorado? Is that what you're asking?
That is what I'm asking. Thank you. You're
yeah.
phrasing it better than I did. And this is something that was discussed because this is something for the commission to consider whether QTS creates a new load, right?
Sure, yeah.
Okay. And getting back to this concept of the parties having, I guess, concerns about QTS's future possible tenants, you were asked questions during the course of discovery about QTS's possible future tenants and their loads. Do you recall those questions from discovery?
I do.
Okay. And as you testify here today, it's unknown whether any future possible customer tenant of QTS has a current Colorado load. Is that right?
Well, since we don't know who our customers are yet, I guess I wouldn't be able to answer that.
Okay. Perhaps this would be helpful if we could pull up from UCA's box hearing exhibit 214, please. And if we could just scroll down to, if right there is good. Thank you. And Mr. Wright, you would agree that this is reflecting a discovery question asked by trial staff? Does that, I see you nodding your head, is that right?
Mm-hmm. Yep.
Okay. And you were the sponsor of this discovery response, correct?
Correct.
And in fact, it looks like maybe there was a back and forth about this discovery issue and this question from staff about customer tenant loads. Is that right?
Yes.
Okay. And I think you've kind of said this, but I want to make sure we're talking about the same thing. Because you don't know who your possible future customer tenants are yet, you don't know whether any of them already have a current Colorado load.
Yeah, there's no possible way I could know that.
Okay. And the only way you would know that is if you knew who your future tenant was. Correct?
That'd be 1 point, yes.
Okay. And if you knew whether they already had existing business that took energy load from PSCo's system, correct?
If they communicated,
Excuse me, Mr. Wright, but I'm going to jump in here a little bit. He said he doesn't know who his potential tenants are. I think he's asked and answered this question a couple of different ways. Maybe we can move on.
Sure. Your Honor, I would move to admit hearing exhibit 214 into the record.
Any objection to the admission of exhibit 214?
Well, again, I would object on grounds we have an objection that's already lodged in the discovery response, that it's vague and ambiguous.
Again, I'm going to overrule this. I'll allow the document. It's Mr. Wright's response that was provided over the objection. So exhibit 214 is admitted.
Thank you. And we can pull off 214. I don't have any further questions about that. Mr. Wright, you talked in your direct testimony about QTS's support of your enthusiasm about Colorado's emission reduction goals. Is that fair to say?
yes.
Okay. And QTS is aware that public service has a responsibility to work towards the achievement of the state's carbon decarbonization goals.
That's my understanding, yes.
Okay. And in your direct testimony, you provided some information about QTS's views on environmentally sustainable practices. Is that right?
I did, yeah.
Okay. I think you noted that you were, quote, pleased with Colorado's commitment to renewable energy.
Correct.
And that QTS is dedicated to driving innovative policy to reduce its carbon footprint.
Correct.
And in this portion of your testimony, you mentioned QTS's, quote, freedom design data centers. Is that right?
I did, yeah.
Okay. And what is unique about freedom design data centers is that they incorporate a cooling technology that makes the data center more energy efficient.
In one sense, yes, energy efficient and water efficient. There's both of those categories, and that's really the part of it that's innovative.
Okay. And I think you noted that these freedom design facilities have standards, building standards that were developed to be LEED inspired. Is that right?
Yes.
And that word inspired, that's your word, correct?
It is.
Okay. And LEED inspired, you would agree, is not the same as a LEED certification.
That is correct, yes.
And you noted that these freedom design facilities will also be, quote, Energy Star certified.
Correct.
And that these facilities, these freedom design facilities, include charging stations, EV charging stations for employees, customers, and visitors.
Correct.
And just a point of clarification is the EV charging station is that energy that QTS will sell to the EV charging customer.
I guess I don't really know the answer to that. We have a partner that installs and manages the EV charging stations, and I honestly don't know the cash flow as to how that works.
Okay.
We know that the customer who plugs their vehicle in typically will get a certain number of hours for free, and then there's a charge beyond that. But I honestly have never used one, so I don't know the answer to that.
Okay. And is it fair to say you don't know if that, I guess, partner that would manage the EV charging, whether they would pass on the EDR energy rate or some other rate?
I think it's some other rate. I don't think it is necessarily tied whatsoever to any actual utility rate that we are paying. I think it is something else, but I honestly don't know a lot about it.
Okay. And this freedom design, this is part of the freedom design that you wrote about, right? You
It was
wrote
so
testimony.
within our standards, we have a standard design for our facilities, and it includes the cooling systems and electrical systems and things like that. And one of the line items in there is that we'll install electric vehicle charging stations, a certain number per site, depending on how many people we think are going to be on the site. Yeah, so I would say yes, it's part of the standards.
Okay. And I just want to clarify, because you talk about this freedom design in your testimony, and you talk about it sort of in connection with QTS's enthusiasm about Colorado's decarbonization objectives. But you would agree with me that you do not write in your testimony that this QTS campus will be built according to freedom design standards.
Well, I guess maybe that wasn't in the testimony, but it will.
Okay. And so that sounds like here, as you testify here today, QTS is willing to commit to, if this is approved for this EDR application, QTS is willing to commit to have this Aurora facility be built in accordance with its freedom design standards.
Yes. Sorry, go ahead.
No. I mean, objection to this line of questioning. I think he just stated that he didn't even think he had anything about the freedom of design standards in his testimony. Nothing about this is contained within the four corners of the EDR statute or the commission's rules. So again, I'm not sure what the relevance of this line of questioning is.
I disagree with Ms. Shields' assertion. Mr. Wright did testify that this is part of his direct testimony. Sort of in that last chapter of questions, we discussed Mr. Wright's testimony supporting the reasons why QTS believed that this EDR application should be approved. I believe the environmental considerations are something that QTS has asked this commission to consider in its determination of whether to approve this application, and have been made relevant by the testimony submitted by Mr. Wright. Again, I disagree that he said it's not in his testimony. His testimony just now is it was. If it's helpful to Mr. Wright and Ms. Shields, I can point the court to where this is discussed in his direct testimony.
Well, I'm reviewing his direct testimony at page 19. Is one reference to the freedom design. I think she can explore what that is, and I think he's answered the question. I'll overrule the objection.
Okay, and and actually, Mr. Wright, that was sort of my questions for you. I appreciate that discussion and QTS's willingness to build in accordance to freedom design. Mr. Wright, I want to follow up with something that Mr. Opp asked you about, and this is kind of the notion, I think, that you've mentioned that this building is already in progress. Is that right?
The shell of the building is, yes.
Okay. And that this QTS project is essentially, this data center is essentially underway, sort of regardless of the outcome of this proceeding.
At least to a point. So one of the things to keep in mind is because we have the standard freedom design throughout the country, and we have a dozen other projects going on at the same time, we will warehouse the equipment that fits out the inside of the building. And if there is a market that is actually growing faster than another, we'll take the equipment out of the warehouse and we'll put it into Atlanta or Chicago or Dallas or Denver or wherever it is that we actually have business to fit out and supply to our customers.
Okay.
Is it underway? Yes, the shell is absolutely underway.
Okay. Well, let me ask you this. This request for this EDR rate, right? This economic development energy rate, this would be an incentive that QTS would receive in addition to other government incentives that QTS has sought and received.
Yeah, so I do not sit on our government affairs team, so I wasn't involved in any negotiations with other economic development packages. I do understand that there has been some other economic development package that has been approved, though.
Okay. And you do understand and you have familiarity because you were asked about these economic development packages in Discovery, correct?
Yeah.
Okay. And if we could pull up hearing from UCA's box, please, hearing exhibit 211. And if we could just scroll down, that's good, thank you. And Mr. Wright, you would agree you were this was a discovery question posed to you by the UCA just last month?
Yes.
Okay. And you were the sponsor of this response?
It would appear that yes, I was.
Okay. And the question was about these other incentives that you had received in particular from the city of Aurora, correct?
I believe so, yes.
Okay. And that's what that says is a question about the city of Aurora, correct?
Yeah.
Okay. And in your response, you respond to see the attachments. Is that right?
Yes, that is right.
Okay. And I think, Your Honor, if I could just pause for a moment here. A question came up earlier about whether this is whether the UCA had any confidential line of questioning. This does get into the economic incentives. I did not see this marked as confidential. This discovery was not submitted as confidential, but I just wanted to flag that for the court before I ask more specific questions.
Ms. Shields?
Yes, and I would confirm that my understanding, subject to counsel for QTS's confirmation, is that these documents are public.
They're public, Your Honor.
Thank you.
Thank
Okay,
you.
thank you, Ms. Crampton.
Okay, thank you. And Mr. Wright, I'm actually gonna put a pause on hearing exhibit 211 for a moment. And if we could pull up hearing exhibit 212, please. Okay, and if we could just scroll down. And Mr. Wright, you would agree that hearing exhibit 212 is another question, a discovery question from the UCA about incentives provided by Arapahoe County as opposed to the city of Aurora. Is that fair to say?
I do see that is what's written on the page, yes.
And you were also the sponsor of this response.
Correct.
Okay. And in sponsoring your response, what you wrote was a reference to the previous question, UCA 3-2. Is that right?
Correct.
Okay. Now I would move to admit hearing exhibit 212 and hearing exhibit 211, please.
Any objection to the admission of exhibits 211 and 212?
No.
Exhibits 211 and 212 are admitted.
Thank you. And if we could go back to hearing exhibit 211, please. And Mr. Wright, you, in this response, what you did is you provided attachments to reflect the additional government incentives that QTS has received in connection with this Aurora data center. Is that right?
It would appear so, but I would need to see the attachments to know that for sure.
Sure. And if we could just scroll down, I know that it looks like approximately 25 pages, so I'm not sure. Yes, that's perfect right there. if we could just go back up. And Mr. Wright, you would agree that this attachment is the incentive payment agreement provided by the County of Arapahoe to QTS in connection with this Aurora data center. Is that right?
Yes.
Okay. And if we could just scroll down, I think it's paragraph, I want to say 6. No. If I could have just a moment, please. And Mr. Wright, what the city or what the County of Arapahoe has agreed to provide in terms of an incentive to QTS is a 50% tax incentive payment. Is that right?
Maybe could you point to the specific paragraph that you're asking about?
Sure, and I'm just gonna pull this up separately so I don't misstate it. Paragraph 4, please. And just let me know when you've had a chance to review. Okay, I see you nodding your head. And so what this agreement is with the city or with the County of Arapahoe is that QTS will receive essentially a payment from the county equal to 50% of the taxes levied by the county, essentially back to QTS. Is that right?
It would appear for sales and use tax, right? This is for the county?
This is for the county, and we're just looking at paragraph 4.
Yeah.
The payment shall equal 50% each year of the amount of taxes levied by the county.
Yes.
Okay. And then if we could just scroll down to paragraph 7. And this agreement with the county, this tax incentive that QTS will receive from the county is for a 5-year term.
Yeah.
And that term can be extended 2 times, correct?
That is the way it's written, yes.
Okay. And not just the way it's written, that's what QTS has agreed to with the county.
Was that a
Correct?
question?
Yes.
Yes.
Okay. And that extension for 2 times is essentially up to a total of 15 years of this 50% tax incentive from the county, from Arapahoe County, correct?
Yeah.
Okay. If we could scroll down to the next attachment, I'm not sure how it will be reflected page-wise.
Ms. Crampton, I'm just going to point out this is cumulative. I hope we can move on. I mean, the exhibit's in the record. It speaks for itself. Asking this witness to confirm that it says it is adding nothing to our evidentiary record. So I don't know where you're going, but let's get to some new evidence.
Okay, well, I'm happy to move on, Your Honor. Mr. Wright, the EDR energy discount rate that QTS seeks in this proceeding is in addition to the incentives already provided by the City of Aurora and the County of Arapahoe that are reflected in this hearing exhibit 211, correct?
My understanding is yes.
And those incentives are done. That's locked in, correct?
My understanding is they are agreed to, yes.
Okay, and that was what you responded to in these discovery inquiries.
Yes.
Okay. And so it's true that this QTS data center will proceed regardless of whether the commission grants this EDR application, correct?
Well, we will at very least build the shell of the first building. That is the project that is underway, and we're committed to completing the shell of the first building.
If we could pull up hearing exhibit 108, please. And if I could have just a moment. If we go to page 14, please. And Mr. Wright, this is your rebuttal testimony, correct?
Yes.
Okay. And what you wrote in your rebuttal testimony is that, quote, it is the case that at this point, QTS will build the facility if the application is denied, correct?
Your Honor, I'm going to object. This has been asked and answered not just by this lawyer, but by prior lawyers, and he's responded multiple times.
It's sustained.
Your Honor, if I could have an opportunity to respond.
No. Yeah, you've asked that several times. He's answered he's going to complete the shell of the first building.
Okay.
I've heard it multiple. You may not, well, you have asked that question, but other counsel has as well. So
Okay.
maybe you can ask where you want to go, rather than asking him what is already in evidence.
Thank you. Mr. Wright, you would agree with me that in your rebuttal testimony, you didn't write that QTS will only build the shell if the application is denied, correct?
I didn't write that, no.
Okay. The QTS data center will proceed if the commission grants the EDR, but adjusts the discount rate to provide a lower percentage of discount, correct?
Sorry, say that again?
The QTS data center will proceed, as you wrote, if this commission grants the EDR, but adjusts the discount rate to provide a lower percentage of discount, correct?
Objection, are you reading from his testimony or where's this coming from in the record?
I'm going to overrule the objection. I think she's asking questions. She's not pointing to any specific words on the testimony. And you can answer the question if you know, Mr. Wright.
Well, I think the answer would be no different than if there is no EDR. The answer is we're committed to building the first phase of this project, the shell of the first building. And as soon as we get customers lined up and sold in the building, we fit it out and we're off and running. That's the concept here. And the better offering we can give to our customers, the faster we will fill this building up and get the facility running.
Okay. And when we look at hearing exhibit 211, and we don't need to pull it up, but you would agree with me, Mr. Wright, that QTS did not seek these incentives from Aurora and the County of Arapahoe on the notion that they would only partially build the facility if they didn't get this EDR incentive.
I guess I can't speak for our government affairs team. I wasn't part of the negotiation with Arapahoe.
Okay. And you talked earlier on, I think, Mr. Opp's line of questioning about how you don't think these government entities would have granted these incentives if they didn't think that this development was a good idea, correct?
I did say that, yes.
Okay. And sort of kind of in that response, speculating about what these government entities may have thought about QTS's proposal, correct?
I guess I was being speculative, yes.
Okay. I know you can't speak for the government affairs team, but it's not your understanding that what QTS proposed was a partial build unless this EDR application was approved, correct?
So I would agree with that, but the incentive is proportional to what we spend on the facility. And so, not only is there a cap, a lifetime cap, my understanding of $19 million, but it is 50% of what we spend. And if we don't spend any money, we don't get any incentive. If we don't actually build the facility out to put any customers in it, there's no incentive there, or a very small incentive there. So the benefit is proportional to what we actually invest in the community.
Okay. And what you wrote is that the QTS will build the facility if the application is denied, right? That's what you wrote.
It appears that, yes, that is what I wrote.
Okay. And when you provided your testimony, you were trying to give the ALJ and the commission as accurate information as possible.
Yeah, I mean, I'll say I don't know that we think through every scenario that you're going through right now. The concept of, are we going to go push dirt and put up walls and build a building? Well, yes, we're already doing that. We've made a big bet saying that we think this is a great market to be in. We think we're very good members of the community. We think that there are advantages of being in Colorado, and we think that this is going to be a great business relationship for the next 40 years. And so, yes, the company makes some bets on whether or not the business model that we've put in front of our board of directors is exactly correct or is mostly correct. And so,
and this scenario we're talking about is the one you wrote about right here, which is the scenario of the application being denied, correct?
I guess so. Yeah, I'm not totally clear on the question here, but yes.
Okay. And so this project could proceed if this commission were to approve the project, but adjust the discount rate to create a step-down discount rate over the 10-year term. Correct?
Objection, Your Honor. This has been asked and answered.
If I may respond, I respectfully disagree. I asked about whether the project could proceed if the commission approved it with a lower percentage of discount. That was my first question. This question is about whether the project can proceed if the commission approves the project but adjusts the discount rate to be a step down rate rather than flat rate. Those are two different questions.
Are you
I'm
asking?
going to overrule the objection. But the problem, could it proceed? Frankly, counsel, it's a tough question for me. Anything could happen. That we have a negotiated contractual agreement, and it could be affected by the ruling in this case. Maybe it is, maybe it didn't. You can ask him if he knows what's going to happen. If you want to speculate into hypotheticals, I guess maybe we'll see how far that goes. Maybe you can rephrase your question.
Sure, Mr. Wright, this project could proceed if the commission approved the EDR discount rate, but adjusted the structure to create a step down discount rate rather than a flat rate. Correct?
You're kind of throwing hypotheticals out there that are very difficult to answer. Do I think the project will move forward? Probably. At what speed? I guess I don't know the answer to that. It could take us 10 years to fill it up, or it could take a year and a half. The more opportunity we give to our clients to have a cost-effective solution, cost-effective, reliable solution with clean energy, the faster we can get this project moving and off the ground and benefiting all of Colorado.
Okay. Thank you. I don't have any further questions.
Okay, thank you. Mr. That's all the cross-examination on the matrix, actually. So we did have the confidential topic though. So shall we follow the same procedure again? Ms. Shields, do you have any redirect on the public portion? We'll withhold on the confidential. We'll handle that at the end of the day.
Yes, that's fine. And do you have any questions, Your Honor?
I do not.
Thank you. All right, I have a handful of redirect questions. All right, I'm going to start with two questions, Mr. Wright. Would you say the cost of electricity is a critical consideration in QTS's decision to locate in Colorado?
Yes.
Would you say the availability of the economic development rate in combination with the other economic development incentives you've received was a substantial factor in your decision to locate in Colorado?
Yes.
QTS will not, under the EDR ESA that QTS has executed, QTS will not start receiving a discounted electric rate until you hit a minimum of 20 megawatts of load. Is that correct?
That's correct. Yes.
So if the tenants don't materialize quick enough, there will be no discount until you hit that minimum of 20 megawatts of load, right?
Correct. Yes.
Okay. You mentioned you think Colorado is a great market to be in. So QTS has a choice where to locate. Is that right?
We do. Yes.
And if QTS did not choose Colorado for this facility or future facility, is it possible you could have selected a utility or a jurisdiction with a higher carbon intensity footprint?
Well, it's possible. Yeah.
If the commission denies this economic development rate or even reduced it, what message do you think that sends to the business community at large or customers who are considering locating here?
Turner, I'm going to object to that question. I think that's beyond the scope of both my cross-examination and Mr. Opp's cross-examination.
Yeah, and I am objecting on that too, especially on foundation, what message it sends to the business community. I'm not aware that Mr. Wright is qualified to speak on behalf of the business community and interpret messages that are being sent or not sent.
I'll sustain the objection. Go to the next question, Ms. Shields.
Mr. Wright, you received a handful of questions early on, particularly from staff counsel, about the number of jobs that this facility might create, about the economic impact of this facility. Could you tell me, assuming full build out of the campus, approximately how much do you think that facility would cost?
We're estimating it to be more than $1 billion.
Okay, so over $1 billion of economic investment in Colorado with this facility.
Correct.
Actually, I'm going to object to that question. He says $1 billion in economic development. I mean, I think that's that's what the facility will cost. That's not what, in terms of what it's going to produce in terms of economic development. So I object to the question as it's phrased.
I think a critical issue in this proceeding is obviously, as staff counsel and UCA counsel have indicated, is the amount of economic development that this facility is going to create. And they've really focused on jobs. It's obvious the statute says nothing about a minimum number of jobs. And so the relevance of the total dollars that this facility is going to cost is directly relevant to the consideration and rebutting everything that they've been asking him.
Yeah, but that's not what the question you, Ms. Shields asked. She said $1 billion in economic development. The cost is not the same as economic development. And so the question conflates the two.
Okay, let's go off the record a moment, and I'm actually going to ask Harriet, can you read back that question? I heard it differently.
Sorry, am I muting? Hold on. Okay. Last question. I think a critical issue that's not him. Okay, so over $1 billion of economic investment in Colorado with this facility, correct?
Thank you. Okay, I'll overrule the objection. Ms. Shields.
Thank you. I have no further questions for this witness.
Okay, and that's the public portion. So we will take up the confidential portion at the end of the day. So, Mr. Wright, are you available to be with us the rest of the day?
Yes, Your Honor.
Then thank you. We'll be recalling you here in a little while.
Okay.
And Ms. Shields, you can call your next witness.
All right. I believe we are calling Mr. Jason Rurup to the stand. Just looking through the list, is Mr. Rurup plugged in? I see his name on the screen. If you could just give us a moment while he signs in.
See. Oh. There we go. Hi there.
Thank you. Now I'm trying to find you on mine. There we are. Thank you. If you would please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Ms. Shields.
All right, Mr. Rurup, good afternoon. If you could please state your name and title for the record.
Yes, my name is Jason Rurup, and my title is pricing consultant.
And are you the same Jason Rurup who filed rebuttal testimony in this proceeding and adopted portions of Mr. Wishart's direct testimony?
Yes.
And if I were to ask you those same questions today, would your answers be the same?
Yes.
All right, since the hearing exhibits have been admitted into the record, I'd like to make the witness available for cross-examination.
Okay. Mr. Valentine, actually, I won't ask you if you need to just say something if you need to interrupt, because I'm noting, of course, you didn't put any time in the matrix. So
That's correct, Your Honor.
For us. Okay, Mr. Opp.
Thank you, Your Honor, and let me take a step back. The reason we're having problems with Box is that my assistant is having a hard time accessing it. So she emailed Ms. Kunkel asking for a new link. And so as soon as we get that, we can load up those exhibits. But I also have an exhibit that would be directed at my for the cross-examination of this witness. So maybe for the sake of efficiency to keep the hearing going on time, maybe it makes sense for staff to go after UCA in this particular proceeding. So I'll be able to get the exhibit up, and once we get the new link to Box.
Okay. Let's go. Excuse me.
I was just gonna, Mr. Opp, Ms. Kunkel's out today. If you can have your person that needs access email me instead. Ms.
Okay,
Kunkel
I'll
will
just
see it.
forward on that email right now.
That was what I was going to address. So actually, we're just going to, let's take just a moment's break. We're not going to leave, but let's give Ms. Federico a moment to deal with your inquiry.
Okay. Just gonna switch screens. Okay, I just hit send.
All right, I just made Miss Graham a co-owner on staff's box account for this hearing.
Okay, I'm just going on mute and call her right now and tell her that she's available to do it now. Okay, she's doing it right now. I'm not gonna need that exhibit for a little bit, so I can get started when I get to that point. We'll just make sure it's in there.
Well, it's okay with me if we want to have UCA go first, if you want
Okay.
to make sure.
Yeah, I think that would be helpful. Thank you.
Ms. Federico can only do one thing at a time, you know.
I got it.
this
I got
hearing. I thought it would be best to get this issue resolved.
All right,
So,
thank you.
Okay, we'll go back on the record then, and UCA, I hope you're ready and available for cross. Is it Ms. Crampton?
No, it'll be Mr. Bunker.
Mr. Bunker.
And I think I'm ready. I could have used a few more minutes, but that's okay. We'll give it a run.
Thank you.
Yes. Good afternoon, Mr. Rurup. Did I pronounce that right?
You did fine, Mr. Bunker. Thank you.
Okay, thank you. I don't know if you've been listening to the hearing, but I am a senior assistant attorney general and I represent the UCA in this case. Let's start with your rebuttal testimony, and that is hearing exhibit 106 at page 5. On the top of the page there, at lines 3 through 9, you indicate you did not file direct testimony in this case, but you are adopting parts of Mr. Wishart's direct testimony. Is that right?
Yes.
And your rebuttal testimony responds to UCA and staff answer testimony and primarily relates to the two Piesco's marginal cost analysis and modeling and the level of the negotiated discount for QTS's economic development rate. Is that right?
I think there are more subjects I cover within my testimony, but I think those issues you discuss are talked about. Yes.
Okay. Thank you for that. And did you hear Mr. Bailey's testimony this morning and his suggestion that I ask you for more detailed discussion concerning the adjustments public service made to the marginal cost calculations, and in particular, his bullet points on page 8 of his rebuttal testimony?
I did.
Okay. Thank you. With respect to the marginal cost analysis and modeling, at lines 15 through 18 on page 5, there you say you present an updated marginal cost analysis, which includes several updated inputs and assumptions based on intervener answer testimony and the timing of this rebuttal filing. Is that right?
Yes, we updated our assumptions in line with the marginal cost methodology presented in Mr. Wishart's direct testimony that I have adopted.
Okay, and the
I'm sorry, I hope I'm not
Let's-
speaking too loudly. I have no
no,
idea.
it's
Okay.
great. No, not at all. And so let me ask you a question. It's a little bit off of track of where I was going to ask you this question, but would you agree that the updated marginal cost analysis, which you present, and those several updated inputs and assumptions, that material replaces the marginal cost analysis contained in Mr. Wishart's direct testimony and attachments?
I don't agree. Mr. Wishart presented a marginal cost methodology, which is based on the methodology determined or settled or agreed to in the EDR settlement. And all I have done is updated the information presented for better assumptions using the same methodology. And also, I believe it's fair to say, bringing up things that were brought up through discovery.
Okay, thanks for that discussion and clarification. Let me see if I can break down what I think I heard. You utilized the same methodology as Mr. Wishart did, but you've updated the inputs and assumptions in your rebuttal testimony.
Yes.
Okay. So if the judge and his advisors and parties such as the UCA were to focus on the inputs, assumptions, and marginal cost analysis, we would want to focus on your analysis as being the most updated or current. Is that right?
I would say from a marginal cost perspective that what's presented in my rebuttal is updated for information that came out of the company's preferred plan, given market information on the marginal generation capacity cost, as well as an allocation of transmission O&M that we've added to the analysis. And I'm sure my testimony has the bullet points that you're talking about that I've added to, and the changes from the direct case.
Okay. So I think your answer to my question was yes, that the judge, his advisors, the parties would want to focus on what's contained in your rebuttal testimony and attachments, correct?
Yes.
Okay, thank you. You're familiar with Mr. Neal's testimony for the UCA, correct?
I read through it at least once.
Okay. And is your recollection, Mr. Neal, stated that QTS's marginal cost of capacity should be modeled using PSCO's 120-day report filed in the company's 2021 ERP and CEP case?
No, I don't recall Mr. Neal making that recommendation. If I recall correctly, and maybe we should bring this up. Do you want to bring up Mr. Neal's testimony to talk about it?
Sure. We can bring up Mr. Neal's testimony, hearing exhibit 201. Page 27. And at lines 12 through 16, Mr. Neal states, UCA recommends that the commission require public service to switch to actual costs from the phase 2 ERP solicitation in the calculation of the marginal cost of generation capacity rather than using generic costs from the phase one of the ERP. Do you see that?
I do see that.
Okay. So now going back to your rebuttal testimony.
Can I get a clarification? I believe when he was making that assumption, it was based, or this recommendation, it was not saying that necessarily that it had to come from the 120-day report, which is what I think you said. So can you point to me where he said something about the 120-day report?
Well, let me ask you this. You mentioned the 120-day report on page 7 of your rebuttal testimony. So let's go there. And perhaps we can kind of cut to the chase on this. On page 7 at lines 18 through 27, here you state you agree with UCA witness Mr. Neal's recommendation that QTS's marginal cost of capacity should be modeled off bid data from the company's 2021 Electric Resource Plan and Clean Energy Plan, and you refer to Public Service's filing of its 120-day report in that ERP case.
Yes, that's true.
Okay, and that's essentially the point I was just trying to nail down, that you agreed with Mr. Neal's recommendation and you summarize that on page 7.
Well, I think there's context that's important here. Mr. Neal was drawing attention to, I believe, what's called the 30-day report and recommending that we use prices from Piesco's 30-day report. That's public information. It's not great information in terms on the general cost of the true market competitive price of resources. It's just a kind of a portfolio average of all the thousands of bids we got. So it's not great information to be basing decisions off of. What we're saying here in this testimony is we didn't think that was great information to use at the time. And I think Mr. Neal kind of took exception to that we had better information available than what we filed in our direct case. We're saying that wasn't great information, but what we do think is good information on what a marginal generation capacity cost should be is what I presented in my rebuttal.
Yes. And
one more point I'll make.
Yep.
Is that the EDR settlement, within the EDR settlement, Piesco committed to reassessing its marginal generation capacity cost off of a simple combustion turbine methodology. And so what we did was in line with the EDR settlement.
Okay. Not to quibble with your colloquy there, but it is important to clarify the record, and that is, I believe Mr. Neal took the same position you did, which is the 30-day report data used by Mr. Wishart was not the most accurate, and that in fact it should the model should be based on the 120-day report information, which admittedly was filed after Mr. Wishart's direct testimony. That is the information that should be used. And I think that's what I heard you saying. And just to clarify, is it your understanding that's what Mr. Neal was also saying?
Mr. Wishart didn't use the 30-day report. Mr. Wishart used the generic CT, which was identified as the marginal generation capacity cost from the EDR methodology. And it's also the marginal generation capacity cost in Schedule EDR of the company's electric tariff. Mr. Neal suggested we should use information from the 30-day report, which was, as Mr. Neal said, I think that 30-day report came out before Mr. Wishart's direct testimony. And so Mr. Neal took exception that this information that we provided is too low, I think was his language. And I would just say that that wasn't great information. We think that the information based on the preferred plan of the 120-day report is better information.
Okay, let's move on. I think the record will be clear as we brief this in our statements of position and throughout the rest of the hearing. So moving on to page 8, and at lines 1 through 6, you indicate the inputs and assumption to the modeling include recently implemented rates from the company's last phase 1 electric case, and also an updated rate escalation assumption from 2% to 2.5%. Is that right?
I see that, lines 4 through 6.
Yes. And with regard to calculating the QTS cost of service, you state on lines 7 through 11 there on page 8 that there was a change to the marginal cost of capacity, and you've updated the analysis to include the company's projected O&M expense for the new transmission facilities needed to serve QTS, and you've used the same updated rate escalation assumption of 2.25% as applied to the QTS revenue forecast, right?
That's what it says.
Okay. And so when we look at your, and we don't need to go to them now, but your rebuttal testimony attachments, which I believe are JAR 1, 2, and 3, that's where we will see the inner workings of these updates. Is that right?
I believe it's 2 and 3, sir.
Okay.
1, I forget what it is exactly, but 2 and 3.
Okay.
2 is the revenue analysis and 3 is the marginal cost analysis.
Okay, thanks for that clarification. Now, and I don't think we're going to need to look at Mr. Bailey's testimony for this, but one of his bullet points was that the updated modeling information included modeling QTS's maximum anticipated load of 252 megawatts. Do you recall that?
Could you just repeat that? I'm sorry. I was a little distracted.
That's fine. One of Mr. Bailey's bullet points, and I don't know that we need to necessarily look at his testimony because it was about 8 words. And that is that modeling QTS's maximum anticipated load of 252 megawatts is one of the items updated via your rebuttal testimony.
Yes, sir. Okay, following you. Within attachment 2 and 3, for example, in attachment 2, there is a revenue analysis that includes a 252 megawatt scenario. And within attachment 3, there's the accompanying 252 megawatt marginal cost analysis scenario. So those, you could think of those as a pair.
Okay.
It should be used together. There's also a higher escalation version within those attachments. And those, again, should be looked at as a pair.
Now, just to clarify, what do you mean a higher? I think you said higher escalation. What do you mean by that?
Well, we could pull that up in the testimony. I think it was in response to one of the interveners' answer testimony talking about what are the effects of companies' higher rates, and that was that scenario, which we'll call it, was in response to that.
My recollection is attachment 2 is confidential, and I believe attachment 3 is as well. So we may have to come back to that later when we do a confidential session. But maybe you could just explain, what did you mean by a higher escalation? Did you mean over 252 megawatts?
Oh, no, sir. So if you look at line 5 and 6 there, talking about a rate escalation from 2 to 2.25%, or we use 2.25% in a rebuttal case. We went to a higher escalation and subject to check, I think it's 5.25% or 5.5%. And we use that consistently through the revenue analysis and the marginal cost analysis to see the impacts of a higher escalation assumption. So it's changing the 2.25% you see there on line 5 to, I believe, 5.5%, subject to check.
Okay, thank you for that clarification. I was not following what you meant by the higher escalation.
Okay, sorry about that.
That's okay. How does this 252 megawatt load estimate compare to the maximum anticipated load of public services current largest commercial or industrial customers?
Regardless of the 252 megawatt, I mean, I think with the 160 megawatt assumption, which is our current estimate, that would make them our single largest customer. So I assume 252 would make them still the largest single customer we would have.
Okay. What is your understanding about the current load estimates for, say, public services 3 largest commercial or industrial customers? In other words, what megawatt load would you estimate for those 3?
I'm sorry, I don't know.
Okay. Okay, if we could go to let's move to page 40 of your rebuttal testimony. And at lines 5 through 10, you summarize Mr. Fernandez's cross subsidization concerns as the assets solely dedicated to the EDR customer and funded by the EDR customer should not be included in rate base for rate making purposes, and that the direct expenses associated with the assets dedicated to the EDR customer and funded by the EDR customer should not be included in any revenue requirement for the rate base for rate making purposes. Do you see that?
I do.
And at lines 10 through 13 there on page 40, you state Mr. Fernandez recommends that the commission should order or issue an order with an explicit prohibition of including any costs associated with the assets dedicated to and funded by the EDR customer in any future revenue requirement, right?
Yes, I think those are direct quotes from Mr. Fernandez's testimony.
And turning to page 41 at lines 8 through 9.
Mr. Bunker, you're reading to me a lot. Let's not ask the question if the evidence in the record says what the evidence in the record says. Have him take a moment, get familiar with it. If you have a question about it, let's by all means get to those. But let's try not to read evidence to me.
Okay, thank you, Your Honor. If we could look at lines 8 through 10 on page 41, here you state Mr. Fernandez's recommendation is unnecessary, right?
Unnecessary and unsupported by the EDR statute and EDR settlement is what it says there, sir.
And does Piesco object to a commission order explicitly prohibiting inclusion of any costs associated with the QTS assets and any future public service revenue requirement?
Well,
Objection, he's seeking a legal position or a legal conclusion. It's outside the scope of his testimony.
And Your Honor, I believe Mr. Ruup is indicating he disagrees, and Mr. Fernandez's recommendation is unnecessary. He says it's unsupported by the EDR statute and the EDR settlement. I believe he's able to answer this question in terms of he's the one who is citing the statute and the settlement.
Right. I think the question was whether or not the company would object to a certain finding or conclusion from the commission in this case.
A prohibition. Yeah, I'll sustain the objection. Perhaps you can rephrase, Mr. Bunker.
Okay. I'll just move on. Thank you. On page 41, lines 10 through 12, here you state the company has identified certain costs in the cost of service for QTS, and can you review those?
yes, sir.
And if we could go to the UCA's Boxcom account and hearing exhibit 207. And this is Public Services response to UCA discovery request number 4-1. And you, if we turn to page 2, you are the sponsor of Public Services response to UCA discovery request 4-1, correct?
Correct.
I'd move to admit hearing exhibit 207.
Any objection to the admission of exhibit 207?
No, Your Honor.
Exhibit 207 is admitted.
If we could focus on the second line of the discovery response, and it starts with the language to explain public service does not track. Do you see that at the end of the second line there?
I do.
And you indicate that public service does not track O&M expenses on an asset level basis, but tracks it on a system basis. Is that right?
In particular, in reference to this transmission O&M question, yes.
And so your response is that, or is it accurate then that public service does not have a mechanism or an ability in place to track the O&M costs that are directly associated with the QTS dedicated transmission facilities, which is the 2.4 miles of transmission line and substation?
That's right. There's no process in place for when O&M work is being done to track it to that level of detail. I believe it's, after listening to the hearing this morning, I think it's 1.4 miles, but I think that's neither here nor there on what we're talking about. But the gist of it is that's a very minor part of the overall transmission system. And so when work is being done, it's not tracked to the 1 mile level.
Okay. So if we look at essentially the next sentence there, which is the sixth line of the response, and it starts with the words consistent with its rebuttal case, public service has. You see that there starting kind of the middle of that sixth line?
Yes, sir.
So the discovery response indicates that public services used an estimated amount of O&M as an allocation method rather than actual amounts of O&M. Is that right?
That's right. This is a common technique used to forecast or to allocate O&M on this type of asset on a gross plant in service basis. And so this is just a general high level top down kind of analysis to try to get at what is the transmission O&M. The attempt is to be transparent in the marginal cost analysis, and that's why we put it in there to show that the revenue received from QTS will exceed the marginal cost to serve QTS, with the inclusion of this transmission O&M, which we consider an indirect expense associated with serving QTS.
So did public service remove direct expenses associated with the transmission assets dedicated to QTS, such as depreciation and property tax expenses, or any other direct expense that would be attributable to this dedicated QTS transmission asset?
Well, sir, the QTS has paid for these facilities.
I understand that, but my question was, have direct expenses such that are depreciation and property taxes, which can be determined in terms of actual amounts, were those removed from the calculation?
Objection is to form. The witness has answered the question that all costs will be paid. There's no depreciation if the full capital costs are being paid by the customer.
And I think the question was a compound question as well. So I'll sustain the objection, and maybe Mr. Bunker.
Thank you, Your Honor. Did public service remove direct expenses for depreciation with regard to these assets?
Yes, sir. There's no depreciation associated with these assets. They're paid for by QTS. Therefore, they don't go through the company's cost of service analysis, which would include depreciation.
Did public service remove property tax expenses from the calculation?
What do you mean by remove, sir?
Take it out of the calculation in terms of the marginal cost analysis.
Are you asking, did we include property tax in the marginal cost analysis?
Yes, did you? Or no, you did not?
The property tax associated with these facilities was not included in the marginal cost analysis, but that is not something that is easily quantifiable, again, at this level of detail, given the small portion of the company's overall transmission system. But I would expect those costs to be de minimis to the analysis.
And de minimis when we're talking a $28 million project to construct this, de minimis, can you put some quantification to that? What kind of number are we talking about?
I really can't, sir. I don't know.
If we could move to page 40 of your rebuttal testimony, that's exhibit 106. And on lines 14 through 19, you discuss UCA witness Ms. Henry Sermos's concern that the dedicated QTS transmission line is an asset that will continue to generate costs such as O&M beyond the 10-year term of the EDR ESA, right?
You're asking me if that's Leslie Henry Sermos's testimony? I believe that's a direct quote from it.
Okay, thank you. And at page 42, 1 through 12, you indicate that the company strongly objects to this assertion, and that's with regard to Ms. Henry Sermos's assertion regarding potential costs beyond 10 years, right?
Let me just read this Q&A, sir, so I know the full context of it. Yeah, so the full context of this, as laid out on the page here, is that once the EDR ESA expires, QTS becomes like any other customer on the company system. And I know there is something in the contract that says that if these facilities are no longer determined to be used and useful, that decommissioning cost is something QTS has to pay for.
And you indicate in your testimony that nothing in the EDR supports this interpretation by Ms. Henry Sermos. Is that right?
Yeah, the EDR statute, sir, is that what we're talking about?
Yes.
Yes, the EDR statute is a comparison of the rates charged to the customer and the marginal costs to serve the customer. There's nothing about, and those terms are related to the EDR or the economic development rate. If you're asking about terms after the economic development rate, I don't believe that's covered in the EDR statute.
So if I understand you, the last comment, you're not aware of any language in the EDR statute that supports your view that costs for a dedicated EDR transmission facility can be passed on to non-EDR customers at any time, including after the EDR agreement terminates?
Can you say that one more time, sir? It sounded like a big statement.
Okay. Are you aware of any language in the EDR statute that supports a view that costs for a dedicated EDR transmission facility can be passed on to non-EDR customers at any time, including after the EDR agreement terminates?
So are we talking about the transmission O&M costs, sir, after the EDR ESA terminates?
We're talking about any additional costs as a result of that dedicated EDR transmission facility.
I think I would just reiterate that I don't think there's anything in the EDR statute that determines how things are handled outside of an EDR contract or outside the terms of an EDR contract.
Okay, thank you. And Your Honor, if I could just have a moment, I believe the questions I have left for Mr. Rurup are all confidential session questions.
Okay.
So if you just give me a moment.
Sure.
Yes, that concludes my public session questions for Mr. Rurup.
Okay, thank you, Mr. Bunker. And we'll go back to Mr. Opp.
Thank you, Your Honor. In follow on with what Mr. Bunker says, I have some questions for this witness that are actually highly confidential. And so I wanted to flag that, obviously. Second, I was wondering if before I begin my cross, if we could take a quick break and then I'll be ready to go.
Yeah, it's approximately time mid-afternoon break, we'll call it. We'll take a 10-minute recess and come back at 3 o'clock.
Thank you.
Thank you. Okay, Harriet, are you ready?
I'm ready.
Thank you. Okay, Mr. Opp. We'll go back
And
over.
Your Honor,
Yes.
excuse me if I may, before we go into the session, Mr. Opp had indicated that he had a line of highly confidential questioning. And I wanted to confirm if that is correct, because we do not have a highly confidential protective order in place in this proceeding. So the company has some concerns if we are in fact going into highly confidential session, that we do not have the appropriate protections or NDAs in place.
Mr. Opp?
Yeah, I mean, the exhibit is highly confidential from another proceeding.
I think excuse me.
Ms. Shields, go ahead.
Yes, I mean, at this point in time, we do not have. Okay. At this point in time, we do not have a protective order in place for highly confidential information from another proceeding. None of the parties to this case have executed an NDA. I don't know what proceeding it is from, to the extent that it was related to the ongoing ERP. Well, as well as any proceeding, there's a reason that the company protects information as highly confidential and limits the disclosure. So to the extent that it included competitive bid information, now is important and as sensitive of a time as any, given that the company is in the middle of the largest ERP it's ever been through. So
without making any assumptions of what it is, Mr. Opp, I think she raises a good point. In fact, it is subject to a protective order and the one in the other proceeding. So that is something that's going to have to be dealt with.
Sure, and I appreciate your comments and Ms. Shields' comments. You know, it is from another proceeding, and so to the extent I could look at the highly confidential protective order that's in that place, and if you want, I could draft a motion tonight or something that asks for similar language along that lines. I would confer with public service about that beforehand, and then those that are qualified to, execute the highly confidential non-NDA. So we may not be able to get to that today. So I'm wondering if Mr. Rorup would be available, at another time, or what his witness availability is.
Your Honor, I might also add, can you mute Ms. Shields? Okay. If we had proper and adequate notice that one of the interveners in this hearing today was going to conduct cross-examination involving highly confidential information from another proceeding, we would have had time to prepare and file a motion for highly confidential protective order and seek an expedited ruling on it. In fact, I probably would have been the attorney to draft that motion. We did not have any notice whatsoever that anybody intended to try to cross-examine a witness on highly confidential information, especially from some other case. We have no highly confidential information in any of the pre-filed information in this case. Had we included highly confidential information in our direct or rebuttal cases, of course, we would have filed such a motion and gotten a ruling from Your Honor on it. So, I hate to say this to my friend, Mr. Opp, but this smacks of trial by ambush. It can't in the middle of a hearing be expected or have Your Honor expected to scramble to try to accommodate a request to conduct cross-examination on highly confidential information without any notice whatsoever, an opportunity to protect this highly sensitive commercial information. In fact, I don't even know what other case this is. I am probably not involved in it, so I can't even comment on whether the protections that were ordered by the commission in that case would be sufficient here.
Well, I think
the other problem is no one who's in this hearing that I know of may have signed a highly confidential NDA that applies to whatever this information is to the extent it comes in the record of this case.
Well, I think it's beyond dispute. It's not protected in this case at this moment. It is subject to a protection and it is not required under the procedural schedule to have been disclosed if it is to be used for impeachment. So, and if it's otherwise, it's probably inappropriate for other reasons. So, but Mr. Opp, if you're going to try and use that document, you've got to figure that out. And I'm not sure how you're going to do it, but that's your job.
Right, and I suggested a solution, and number one, this is not trial by ambush. I'm not doing that. I mean, so as well, litigators know, sometimes decisions are made on the fly during, while preparing for cross-examination. And so, and I agree with you that in terms of those, I propose the solution in terms of looking at the protective order that's in place in that other proceeding, and then doing something based upon that and ask for expedited ruling. I said that's that is the proposed solution. So I could probably take that offline with public service, but I did propose that.
Well, Your Honor, I appreciate the proposal by Mr. Opp. At least tell me what the docket number is in this other case, so we can have somebody look at this tonight. And we're happy to visit offline with Mr. Opp about this.
I'll send you an email instead of just.
Thank you, Mr. Opp.
Right.
Okay, so we will pick up then, Mr. Opp.
Hey, Mr. I know Mr. Bunker asked you Rurup. Am I pronouncing that correctly?
Think of rhymes with Europe.
Okay.
That might help.
Okay. Well, I mean, I have had people mispronounce my last name, so sometimes happens. My name's Kevin Opp. I'm an attorney representing trial staff in this matter. We haven't met before, so nice to meet you. And
likewise, thank you.
So let's turn to your rebuttal testimony. And so that would be exhibit number 106. And if you can go to page 25. Okay. And let's scroll down to line 13. And so take a look at the first Q&A in the, your first sentence, and take a look at the first sentence in your answer and let me know when you're ready.
I'm ready.
Okay. So I just want to make sure that we're talking the same language. You'd agree that the standard EDR tariff does not apply to this non-standard EDR customer, correct? QTS?
No, sir. There are provisions of the EDR proceeding and EDR settlement. The company's position is applied to all EDR customers, and the company's attorneys are happy to provide a legal brief on that if you would like.
I'm not going to presume to tell public services attorneys what to put in a brief. They're great at it themselves. So I guess, so it's your position that the settlement reached in that in 20A, proceeding number 20A-0330E governs this standard non-EDR customer in this proceeding?
There are provisions within that settlement that do apply to EDR customers. If you look right here at line 16, the rate riders applicable to EDR customers include the
right.
rate.
Okay, and that's just EDR customer. All right, let's just move on. Let's turn to page 27. And let's go to lines 14 through 17. And then take a look at that and then let me know when you're ready.
I'm ready.
Okay. And now, all right, what costs are you're familiar with the transmission cost adjustment rider?
The TCA, sir?
Yes.
I'm generally aware of it, yes.
Okay. And do you know what costs are recovered through the TCA rider?
Speaking in general terms, the costs on the transmission system that add capacity to the transmission system.
Okay, well, let me make it maybe a little more clear. It covers new transmission investment, correct? Looking at
that may be a little bit beyond how I understand the TCA. I understand that there's costs recovered through the TCA related to transmission investments, and there are costs included in base rates that are transmission investments, and that there are some recovered there. Over time, those TCA rates or the cost of the investments in the TCA are moved to base rates. That's my general understanding of the TCA and what you're saying. So I think there's some costs outside of base rates related to transmission investments that the rider pays for, and then those are.
and these are new transmission costs that are being added incrementally, correct? I'm talking as a general matter.
Mr. Rob, sir, Ms. Counsel and witness, please. We can only hear one of you at a time. Mr. Opp, you get to ask the questions. Mr. Rurup, you get to answer the questions, and let's not walk over each other. Mr. Opp, why don't you restate your question, and then we'll get an answer to it.
Okay. I'm not looking specific. I'm talking in general. You would agree that the costs that are recovered through the transmission cost through the TCA rider are costs related to new transmission investment.
I generally agree. Yes.
Okay. Yeah, that's all I was looking for.
Okay.
So, those are the new incremental transmission costs.
Yes, I think those are transmission costs which are not currently in base rates.
Okay. And that's a great answer, because that goes next to my next question. So existing embedded costs are not recovered through the TCA. Those are in base rates, correct?
I don't know if I necessarily agree with your characterization. I think, again, there's some transmission costs, which are investments, which are recovered in base rates. There are some that are recovered in the TCA. If we can agree to that, I'm not sure what else you're asking me.
Okay. Well, how about this? If transmission upgrades were needed to deliver generation to a load such as QTS, where would the cost of those transmission upgrades be recovered?
Well, the company actually did a study that identified the transmission upgrades necessary to serve QTS.
That wasn't my question. My question was, if their upgrades are needed to deliver load such as QTS, where do those costs of that new transmission, where are they recovered from?
Objection, calls for speculation.
I'll overrule that objection. You can answer the question if you know, Mr. Ruhr.
Yeah, if Mr. Opp would repeat, please.
Okay, so hypothetically, if transmission upgrades are needed to deliver generation to a load such as QTS, those costs of that new incremental transmission, they would be recovered where would they be recovered? Through the TCA?
Well, I think it's a broader subject that you're bringing up. From perspective of the EDR statute, it would be, would that investment be required if not for QTS's load? And that's what my testimony is based off of. If you're saying that, I guess I don't agree with your hypothetical.
So I have an issue with the foundation of the hypothetical too. You might rephrase.
Okay. Well, all right, let's talk about real world in terms of, instead of going on hypotheticals. If we can go to staff's box and turn to hearing exhibit 304. And I'll represent to you, Mr. Rurup, that this is the 100, if we could scroll down a little bit, please. And so this is the public version of the 120-day report that you were talking about with Mr. Bunker. Do you recognize this?
Yes.
Okay. I asked that the commission take administrative notice of this document that was this public version that was filed on September 18th, or is dated September 18th, 2023, and proceeding number 21A-0141E.
Any objection to admission of hearing exhibit 304 by administrative notice, that being a copy of the public service 120-day report, the public version filed September 18th in 21A-0141E.
No objection on administrative notice, though I'd note this witness was not a witness in that proceeding.
It is admitted, and we can get to objections when we get to questions.
Okay.
Mr. Valentine, did you want to be heard?
I did, Your Honor. This is quite a lengthy document, and just putting the whole thing in the record, I mean, technically it meets the requirements for administrative notice because it's in the company's files, but the company, Mr. Opp, hasn't indicated what portion of this is relevant, and I guess I would object to the whole thing being put into the record. If he wants to ask questions about specific pages of this document, that would be fine, but the whole thing, it doesn't seem relevant.
Mr. Opp, you want to address that objection as to the entire document?
I mean, well, I'll note that for his objection, Mr. Valentine's acknowledged that this actually meets the requirements for taking administrative notice. And so I'm not aware of anything that says I'm going to be referring to specific pages in it. So, I'll direct it, and those will be in the transcript and in the record. So if I'm referring to specific things, then they'll know the relevance of it. I'm not going to refer to the entire thing, but it's fairly easy to scroll to get to the specific pages that I want. So I guess I'm not understanding the objection.
I think the objection is 184 pages of a whole lot of material. And what's the relevance of the entire report to this proceeding?
Well, all right, there are portions of it. I mean, there are tons of pages of lots of documents and throughout the entire record. So I guess I'm not seeing that 184 pages are going to make a huge difference in terms of moving the needle in terms of the number of pages that are already in the record, especially when I'm going to be referring to specific pages.
Well, I'm going to take a brief moment. Not going to take a recess. I'll be back momentarily.
Your Honor, may I chime in for a moment?
Sorry, who was speaking?
Austin Rushoff on behalf of CEC.
Yes, sir.
I was just going to say, CEC also intends to ask this witness questions about the 120-day report, and we would support the entire report going to the record. You know, we think the entire report backs up the resources that are selected as part of the CEP portfolio, and we think just in the interest of completeness, it makes sense to have the entire report in the record.
Okay, I think I'll overrule the objection, but it is going to be admitted for what it is. It's the public service report. It's on an ongoing proceeding before the commission. The commission has not rendered a decision in that proceeding. Of course, it'll be given appropriate weight. The document is much more broad in scope than this proceeding, but we've heard many references to this report. as the basis of other items, portions of testimony.
Your Honor, may I just ask for a little bit of discretion to respond to this? The issue isn't so much the discussion of the report, it's the use of the report broadly for issues not discussed with witnesses that I'm concerned about. If they want to refer to specific pages of the report, that's fine, but then to refer to other sections of the report in a statement of position, for example, creates real due process concerns, because the company's witnesses and Mr. Wright won't have had any opportunity to address those questions. So if you want to ask a question about page 50 of the report and the witness can respond to that, that's fine. But the parties oughtn't to be permitted to then point to other pages of the broader report that the parties haven't had an opportunity to address in live testimony. So I would ask for a limitation on how this report can be used. Thank you.
Well, Your Honor, I haven't, I mean, I'm not writing, I haven't gone to writing the statement of position yet because, you know, we have to see how the evidence comes out in this case. I mean, so I'm planning on asking the witness some specific references to other things. I mean, in terms of not being company being able to respond, I guess I don't have a great answer to that because this is the first time I've heard that request in a PUC proceeding. So, you know, I don't really know how to respond to that.
Well, here's what I think I'm going to do. I'm not going to take administrative notice of it right now. I think you can lay a foundation through a witness and you can ask questions to develop the evidence if you want to try and do that on cross.
How about this? I just think this is far more complicated than it needs to be. How about this? We have this as it is. I refer, and then tonight we can, well, I have two options. Tonight or tomorrow morning, I can, you know, ask the witness, change the thing so it's referring, so the exhibit refers to the specific pages that I'm going to be referring to. And so that would mean I'd have to submit a new exhibit, get it, prepare it and submit it tomorrow. Or I'm looking at the time and it probably looks like Mr. Rurup will be testifying tomorrow as well. So I'm not trying to kick the can down the road yet again. But if we want to do it that way, I guess I could, you know, go after CEC, does their, you know, cross-examination and then still have prepared that. So, I mean, if that's I think that's the, you know, way to get at this. I just think this is being more being broadened more than it really needs to be.
I think we'll proceed down that path. You and Mr. Reshoff can identify portions of the document that you're asking to bring into the record, prepare that exhibit. We'll take a look at it, see who objects, and we'll go from there.
Okay, so
that might have to affect some scheduling and coordination, but we can figure that out.
Okay, well, I mean, I guess then I would need to get with Mr. Rushoff for that, but then since I'm going to do it that way, I guess I would ask to be able to, you know, do cross on this witness, then start it up again tomorrow morning.
I'm confused why that's necessary. It sounds like you're prepared to go forward with cross.
No, I am, but I maybe I misheard. Maybe I misheard. Maybe I misheard ALJ Adams, and if I did that, I apologize. What I heard was that he would like me to confer with Mr. Rushoff, prepare an exhibit that just has the portions of it where testimony is going to be granted, and then ask questions based upon that new exhibit. That's what I heard.
And that's what I think is best.
Okay, and so given that, I I can't then ask my client of questions until that new exhibit is prepared. So
Right.
that's what I'm asking to be able to go in the morning.
And I'm
Your Honor, if I could, please.
briefly,
Not to completely change the whole focus of this, but this 120-day report is already in the record as Mr. Neal's attachment CN-9, 184-page document. And so if Mr. Opp and Mr. Rushoff would like to ask questions from Mr. Neal's attachment CN-9, it is already in the record.
Thank you, Mr. Bunker, and I should not be wanting it in again. There you go, Mr. Opp. You can continue your examination.
I appreciate that, Mr. Bunker. You just solved a lot of issues. So let's turn to Mr. Neal's answer testimony. And I gotta look and see what.
If I can help, it's hearing exhibit 201.
201. Okay.
And it's attachment CN-9, and that's the public version of the 120-day report.
All right, now let me go back and see what my question was. All right, Mr. Rupp, I'm ready. So would you, would surprise you to hear that Public Service estimates that approximately 2.1 billion in transmission investments are needed by 2030 to support the delivery of energy into the Denver metro area?
Do you want to point me to where that is in this report?
Sure. Let's turn to page 130. And let's look at table 35 right there in the center. And that first line.
I see it. Thank you.
Okay. And so, all right. And you have no basis to disagree with the company's estimate of the 2.1 billion that are included in this report, correct?
No.
All right. And given the timing of this, if we can go back to the very first page again. And scroll down, please. We're looking at some September 18th, 2023 date. So this information was, the Public Service only recently became aware of this information, correct?
I think you're asking me something I can't respond to because I don't have personal knowledge of this proceeding to the detail you're asking.
Okay.
I would say that I became aware of this sometime after September 18th, 2023.
Okay. Well, all right. If you became aware of this sometime after September 18th, 2023, like you just said, has there been a study of these costs to understand the incremental impact of the QTS load?
Objection. We have a dedicated transmission engineering witness who specifically speaks to the transmission planning and the company's network upgrade analysis that we did with respect to this particular customer. It's Mr. Parker Rozak. He's scheduled to go on next.
Well, I mean, I think this is within the scope of Mr. Rurup's testimony. He refers to this report on multiple pages within his testimony, within his rebuttal testimony. And we were just talking, he was talking about the riders. And so we're going in with that. And my question was fairly straightforward. Has there been a study of these costs referring to this 2.1 billion? He's part of this proceeding and he does pricing. Are you aware, has there been a study of the QTS costs to understand the incremental impact of the QTS load on those costs? Are you aware of a study on that?
I'm aware of a study on that, and I would just repeat my counsel's
You just answered my question. You know, Mr. Rivera, you answered no, you weren't you weren't aware of it, and that answers the question. Thank you.
I don't think I said no, sir. I just said I'm not aware.
And that's what I said. I just said you said you weren't aware. I literally just quoted you. All right, so let's go back to our earlier discussion about the purpose of the TCA in general. So these this 2.1 billion in transmission investments, you would assume some of these will be recovered through the TCA at least. You'd agree with that?
Your Honor, objection. Is Your Honor have previously noted, this is a pending proceeding. We're waiting for a decision from the commission. We have reply comments, in fact, due, I believe, Monday. So the estimate that he's pointing to is not an approved number or a certain number and is still the subject of pending litigation.
Okay, I'm just asking whatever that number is. The estimate, some of those costs will be recovered by the TCA. That, I mean, my question is fairly straightforward.
Well, and I think my objection is pretty straightforward, which is that there is no commission order approving whether or not those costs will be recoverable through the TCA.
I'm going to sustain that objection because there is no order that they're going to be recoverable through the TCA. However, I think you can ask I think the operation of the transmission improvements and how those will be recovered or how they have in the past might be, and you might be able to get there. But these costs have not been approved for recovery anywhere. It is a pending proceeding.
Okay. Well, let me lay a foundation then. Let me ask you, how long have you worked with Excel Public Service?
Actually, since 2003.
2003, okay.
Yes.
And since that time, Public Service has done this, well, this ERP right here, the 2021 ERP, this isn't the first ERP that Public Service has done since 2003, correct?
No, sir. In general, yes, there's been multiple ERPs since 2003.
Okay, and so in those ERPs, are you that ultimately the amount of transmission costs was approved, as Ms. Shields was referring to, in those prior ones that went through the commission, correct?
I don't have firsthand knowledge.
You don't.
Certainly, some transmission was approved. I don't know if all of it was approved. That's
right, and I just
question.
Right, and my question was, there was a certain amount in those things that the commission approved on transmission. You'd agree with that?
I don't know, sir, if I totally agree with that, sir. I think there's follow-on CPCNs required for a lot of these projects. So whether what was proposed in the plan was approved or not, I'm not really sure. I think there would have been CPCNs that would have covered that.
All right, let me ask you this. Let's just talk about I'm with the caveat, understanding that this 2.1 billion is subject to whatever the amount is that ultimately the commission approves. So do you know that how much of those costs are being driven by the load represented by QTS, which has the potential to be the largest load on the Public Service Commission? Do you know how much whatever those costs would be?
I don't.
Okay, all right. I think that's all I have. And then I will send an email to Ms. Shields and Mr. Denman and Mr. Eisenberg at the conclusion of the proceeding, or at the end of the day.
Okay. Thank you, Mr. Ott. And Mr. Rushoff.
Yes, thank you, Your Honor. Good afternoon, Mr. Rurup. My name is Austin Rushoff. I represent CEC in this proceeding. It's nice to meet you.
Nice to meet you.
I want to set the table a little bit, go back to some of the questions you had with Mr. Opp at the beginning of his questions. So in this proceeding, we're considering a non-standard economic development rate or EDR contract. That's right?
Yes.
Okay, and that means that the EDR customer's load will be greater than 20 megawatts, correct?
Well, as a point of technicality, we can have EDR customers that are less than 20 megawatt on a non-standard EDR if there's any deviation from the standard EDR tariff. But that's a nuance.
Okay. But in fact, this is marked as a non-standard EDR contract, right?
Yes, sir.
Okay. And QTS's expected load is expected to grow to perhaps 160 megawatts. Is that correct?
That's our current estimate, sir.
Okay. And I think we've talked a little bit in this hearing today about how if that were to come to fruition, QTS will be PSCo's largest or one of its largest customers. Is that right?
Correct.
Okay. Does PSCo currently have any standard EDR contract customers?
That'd be a question for Mr. Bailey, sir.
Okay, you're not aware if Excel has any EDR contract customers right now?
I don't have personal firsthand knowledge of that. I was not a part of any standard EDR proceeding or anything of that nature.
Okay, I think that was in testimony already earlier in this proceeding. Are you aware that the standard EDR, under the EDR settlement that we've been discussing, that you discussed in your testimony, the standard EDR program is capped at 130 megawatts. Is that correct?
Yes, I saw that earlier in the tariff when it was pulled up. There's an enrollment cap. I think it's termed in the standard EDR tariff.
Correct. And you're aware that that enrollment cap is 130 megawatts?
Yes, I think I recall that number.
Okay. So if the QTS EDR contract was approved, it's potential that this non-standard EDR contract would be larger than the entire standard EDR cap. Is that your understanding?
Yes.
Okay.
I would, yes, I think that the potential was there. If they get to their full 160, they would exceed the cap. Yeah.
Okay. And I want to talk about PSCo's proposal to charge or not charge QTS certain riders. And you spoke about this a little bit. So under the QTS EDA, the company proposes that QTS will pay the general rate schedule adjustments, the EDR electric commodity adjustment, the demand side management cost adjustment, the renewable energy standard cost adjustment, the clean energy plan adjustment, the transportation electrification programs adjustment, and the clean energy plan rider. Does that sound correct?
Yeah, I kind of stopped paying attention there for a second, but did you mention the RESA and the SEPA, the SEPA?
I did. Yeah, let's go ahead and pull up Mr. Wishart's direct testimony. You have adopted portions of that testimony, correct?
Correct.
Okay, and if we could pull up hearing exhibit 103. And page 14, please. If we could look at lines 15 through 21. Okay, and that's where I retrieve that information. So if you could review the Q&A on beginning on line 15 and running through line 21. And confirm that that's your understanding.
That is my understanding, sir.
Okay. And among the reasons why QTS will pay all of those riders is to avoid having non-EDR customers subsidize the cost of providing service to QTS. Is that right?
I think the terminology used here is that these are all riders that could cause incremental cost of service. And as well, some of these riders are associated with state policy, such as the RISA, the SEPA. There's some involved with beneficial electrification, energy efficiency, clean transportation, et cetera. So not all of these, I would say, are directly related to avoiding cross subsidization, but they do reduce what other customers would otherwise pay.
Okay. The EDR contract statute requires an EDR contract to demonstrate that non-EDR customers will not subsidize EDR customers. Is that correct?
Yes, sir.
Okay. So I want to get to the TCA and the PCCA. So under the company's proposal in this case, QTS will not pay the transmission cost adjustment, the TCA, and the purchase capacity cost adjustment. Is that correct?
It is.
Okay. And if you could please if we could pull up hearing exhibit 106, which is your rebuttal testimony. Okay, and please turn to page 24. And there we could scroll down to the second half of the page. On line 13 there, you discuss staff witness Aaron O'Neill's position that QTS should pay all rate riders, including the TCA and PCCA. Is that right?
Yeah, I believe that's Mrs. Neal's recommendation.
Right. And would you agree with me that the TCA and the PCCA generally apply to all PSCO customers? Is that correct?
Yes, of course.
Okay.
That's standard charge under the PSCO's tariff.
Okay. Looking specifically at line 18 there, you state Ms. O'Neill advocates for a blanket finding in this limited scope proceeding that all non-standard EDR customers should pay those riders, including QTS. Can you clarify, by limited scope proceeding, do you mean that in this proceeding, the commission is only considering the QTS non-standard economic development rate?
The company's only brought forward approval for the QTS EDR ESA. I think Mrs. Neal's recommendations are broader than the company's application.
Right, and I'm not asking about Ms. O'Neill's recommendations, but I'm asking what you specifically meant by limited scope proceeding. And to clarify, you meant that in this case, we're only looking at the QTS contract. Is that correct?
Correct, sir.
Okay, and it's my understanding that you disagree with staff's position that QTS should pay the TCA and PCCA. Is that right?
Yes, the broader scope of that is that there's a marginal cost methodology associated with the EDR settlement, which riders are included, excluded. We've implemented that here with this analysis and application.
Okay, let's turn to page 25. And specifically lines 14 and 15. And in response to staff's position that QTS should pay the TCA and PCCA, one reason you you provide for not charging those riders to QTS is that those doing so would be inconsistent with the treatment agreed to in proceeding number 23A-0330E. Is that correct?
Yes.
Okay, and I wanted to get back to your questions with Mr. Opp a little bit because it seemed like he was asking you whether the settlement agreement in that case applies to just standard EDR contracts or if it also applies to non-standard EDR contracts. So, and I'm going to assume you're generally familiar with that settlement. Is that correct?
Yes. Although
Okay.
I was not a party to it. I was in this position after all that was settled. So not a direct participant, but I have read the settlement agreement.
Okay, and you rely on it here in your statement on line 14 and 15, correct?
Correct.
Okay, so to clarify, do you agree that that settlement only sets the terms and conditions for standard EDR contracts?
No, as I believe I told Mr. Ott, the company's position is I think we looked at this very same testimony, line 16.
Okay.
Provision within that EDR settlement actually apply to all EDR customers.
Okay, if we could pull up that settlement, and I believe it's already been admitted as hearing exhibit 204. And that's the decision which includes the settlement. And if we could go to paragraph 32, I apologize, I don't have the page handy. Yeah, so this is the commission's decision. And have you reviewed this decision in the past?
The commission decision, I am not as well familiar with that, I will admit.
Sorry, that broke up a little bit. I didn't hear your answer.
Oh, I said I am not as familiar with the commission decision as I am the EDR settlement, but I'm generally aware that they approved our settlement agreement.
Okay, so you haven't really reviewed the decision?
Not into great detail.
Okay. Are you aware that the commission provided sort of their justification and discussion of approving the settlement in the decision?
I'm not familiar with the commission's justification and other things you said.
Okay. Well, we can look at the language here. In paragraph 32, the commission said, turning to non-standard EDR contracts, public service proposes that they would be available case by case to qualifying EDR customers seeking to add or expand load over 20 megawatts. The rates and terms of these contracts would be individually negotiated. Do you see that language?
Yes, sir.
Okay. And I want to look, if we go back to hearing exhibit 103, which was the direct testimony of Mr. Wishart, which you have adopted. If we go to page 11. Page 11, line 8, please. Okay, and there, Mr. Wishart testified, the question was, does the EDR settlement address pricing for non-standard EDR contracts? And his response was,
page 11 is a page of the Mr. Wishart's testimony that was adopted by public service company witness, Mr. Bailey. Just wanted to point that out.
okay.
I have additional objections, but for now, I'll leave it at that.
Okay. Do you see Mr. Wishart's testimony here?
Yes, sir.
Okay, and you see that he responds that the answer is no.
I'm sorry, sir. Did You said that I said no, or that the answer is no?
The answer is no.
I see that the answer is no.
Okay, if we could turn to page 27. Is this a portion of the testimony that you've adopted?
It's possible.
It's possible. Okay. Do you see there on line 1? The question is, does the EDR settlement dictate which riders should apply to non-standard EDR contracts? And the answer is no, it does not. Do you see that testimony there? And is this, you're not certain if this is testimony you've adopted?
I assume if my counsel didn't object that this is mine.
Okay. So therefore, would you agree with me that the settlement agreement that you referenced in your testimony does not prescribe which riders should apply to this non-standard contract?
No, I don't, sir. What's gone on here is that the company has reevaluated the EDR settlement, and in our rebuttal position clarified that the EDR settlement actually applies to, or certain provisions of the EDR settlement apply to all EDR customers. And as I said to Mr. Ott, the company's legal team is happy to provide a legal brief on that interpretation.
Okay, so that settlement, don't recall the date, but that decision was, let's see, I think we have it handy. That decision was May 19th, 2021. Does that sound correct? Or at least generally.
Which provision are you referring to?
The commission's decision in 23A-0330E. I guess my question, the specific date isn't necessarily relevant, but it was issued a few years ago. Is that correct?
That would
Well,
make sense, sir.
it is a decision that Mr. Rurup has already stated he's not familiar with.
Okay. But he does discuss it in his testimony, correct? Mr. Rurup.
Perhaps if you could pull up where I do, at this particular juncture, I'm not for sure if I would generally assume that I do mention the commission's approval of our EDR settlement. That's okay.
I'm sorry, say that again?
I said, I would assume that my testimony does mention the commission's approval of our EDR settlement. So if that's what you needed to know, I'm comfortable with that.
Okay, so yeah, I mean, we can, I don't think we need to pull it up, but a few questions ago, we looked at your testimony on page 25, and you said that staff's, Ms. O'Neill's position, that QTS should pay the TCA and PCCA, is inconsistent with the decision in 20A-0330E. Is that right?
Yes, I believe that's what my testimony says. That's what we just reviewed a few minutes ago.
Right, okay. And then Mr. Wishart, his testimony, hearing exhibit 103 in this proceeding, was dated June 23, 2023. Is that correct? And you've adopted that testimony, some of it.
Subject to check, sir. I'm willing to accept your dates.
Okay, sure.
Dates.
I guess what I'm getting to is that, should I understand that when the company filed this case, its position was that settlement decision in the standard EDR case meant that, or that settlement decision does not prescribe which rider should apply to QTS. That was the company's position at the beginning of this case. Is that correct?
I would say that, yes. In our rebuttal, we are showing our position on the EDR settlement, and I just reiterate that the company's legal team is willing to provide a legal brief on that subject.
Okay, let's turn to your rebuttal testimony, page 26. We might be there, lines 6 through 12. Could you review that testimony, lines 6 through 12?
Yes, I'll review that.
Let me know when you're finished.
Okay,
Okay, and there you discuss the commission's approval of the terms of the EDR settlement, correct?
correct.
And one of the concerns the commission's identified that you discuss here with EDR contracts was ensuring that an EDR customer is not subsidized by non-EDR customers. Is that right?
Yes, as related to writers.
Well, I think the commission would. Do you agree that all aspects of an EDR contract, the non-EDR customers should not subsidize EDR customers?
That's in statute, sir.
Okay, and you would agree with that?
That I agree that that's in statute? Yes, sir.
Okay. And you would also agree that the statute specifically requires commission approval of non-standard EDR rates separate from the standard EDR contracts?
Yeah, I think the commission's decision was contracts greater than 20 megawatts are a non-standard contract that require commission approval in a separate application.
And you would agree that the reason for non-standard contracts needing separate approval is again to allow the commission to ensure that that contract complies with the statute?
I don't know why the commission required the requirement above 20 megawatts to be non-standard, sir.
Okay, I'm gonna move on. We were talking about the 120-day report and the ongoing Excel electric resource plan. You're generally aware of that proceeding, is that right?
Yes, sir.
Okay, and you're aware that the ongoing ERP process includes the clean energy plan, is that correct?
That's correct, sir. Clean energy plan required in this ERP is the company's plan to get to the 80% reduction of carbon emissions by 2030.
Right, and so you're aware, we were talking about earlier, the company recently submitted the 120-day report in that proceeding, which was following its RFP process, correct?
Yeah, it's part of the RFP process.
Okay, and do you generally understand that the 120-day report presents the company's preferred resource plan that includes significant investment in new generation and transmission resources?
Yes, the preferred plan is significant investment in renewable generation and transmission.
Right, and are you aware the 120-day report estimates that the plan will cost around $44 billion on a present value basis?
No, sir, I'm not.
Okay. If we could pull that up, I'd like to look at that specific piece of the 120-day report. So I believe that was hearing exhibit 201.
I think it was 201, I think attachment 9. Does that sound right? CN 9?
That does sound right. Thank you.
Okay. And what page did you say?
15, please. Okay. So if you look in that paragraph, we could scroll down just a bit. And that last paragraph, kind of right in the middle, 1, 2, 3, fourth line down in the middle, it states that over an extended horizon through 2055, the preferred plan costs approximately 44.2 billion on a not net present value basis. Do you see that?
Yes, sir, see that.
Okay, and then are you aware that the 120-day report also calls for approximately 2.8 billion in new transmission investment?
I believe it was Mr. Ott pulled up a table. We talked about the Denver Metro upgrades being 2.1 billion. I don't recall the rest of that table.
Okay, and we can just scroll up a little bit to page 12. Right, and then there on the just the second sentence on this page, it says, it's referring to the preferred plan, and it says it works in concert with approximately 2.82 billion in additional transmission investment. You see that information?
I do.
Okay, and the CEP preferred plan calls for approximately a little over 7,000 megawatts in new generation resources. Are you aware of that?
Subject to check. Is there somewhere you'd like to go in this table to?
We could go to page 21.
Oh, there you go.
So are you aware of the investment that's in the preferred plan in new generation resources?
Let me familiarize myself here.
And while he's familiarizing himself, I'd object. We started talking about the TCA and PCCA from Mr. Rurup's testimony. We are going down the rabbit hole again of the 120-day report, which relates to a proceeding Mr. Rurup is not a party to. He is not a witness to. It has not been approved. It involves transmission costs that have not been approved, let alone for recovery through the TCA. So I'm just trying to figure out how this is relevant to this proceeding.
Okay. Mr. Rurup testifies that QTS's future load was included in the resource portfolio. That load was included in the analysis the company did to select this preferred plan.
I'll overrule the objection.
Okay, so the question was, are you aware that the preferred plan includes 7,192 megawatts of new generation capacity?
Yeah, based on table 2 here of the 120-day report, I am.
Okay, and if we could go up to just the previous page, page 20. And that table there, sorry, if we could scroll down a little bit. The table there shows the preferred plan, then the selected bids, and the last column says in service date. So do you see that these new resources in the preferred plan, should the commission approve the preferred plan, are projected to go into service between 2026 and 2029?
Yeah, I do see that.
Okay. And
little curious about some of those dates, but I see that's what it says here.
Okay, that's at least what's provided in the preferred plan. We agree on that. Okay. The QTS facility we've discussed is currently under construction. Is that right?
Okay, I see note 1 there, sir. I'm just trying to clarify. In service refers to the first summer the unit is available. Okay, that makes a lot more sense to me now.
Okay. The QTS facility is currently under construction. Is that right?
I'm generally aware of that, but I think that was a better question for Mr. Bailey and Mr. Wright.
Can we assume that these new resources in the preferred plan, if they are approved, at least in part, will serve QTS's load?
company's existing system and new resources will be serving QTS load.
Okay, and as I mentioned earlier, you testified that a significant portion of the full potential QTS load was included in this preferred plan, in this analysis. Is that correct?
Company included an estimate of the load of QTS in the preferred plan.
Okay.
I'm sorry, let me rephrase. The company has an estimate of load in the load forecast used in the resource planning process. And that's probably a more accurate statement. Or that is a more accurate statement than what I think I said.
Okay, and you said QTS will be served by the overall portfolio of resources that the company uses to serve all customers, correct?
Correct. QTS will be integrated into our system and served on a real-time basis, hour to hour by marginal units.
Okay, so QTS won't be served by any dedicated or directly assigned generation resources, correct?
That's correct.
Okay. Therefore, electricity generated by PSCo's overall resource portfolio will also be transported to QTS using PSCo's transmission grid. Is that correct?
Yes, sir.
Okay. Okay. And we talked a little bit about how this preferred plan calls for significant transmission investment. Could we please turn to page 170 of the preferred plan? The 120-day report. I apologize. Is that? One moment, that's not the page I had. I think 169, if you could scroll up one page. Okay, yeah. So under the bullets, this first full paragraph here, if you could look at the last sentence in that paragraph and review that sentence, please.
I've reviewed it. Thank you.
Okay, so the 120-day report does state that transmission costs will be recovered through traditional rate recovery, including the transmission cost adjustment or TCA. Is that correct?
That is what this page says, and that is the company's proposal within this document, but that will still be decided by other proceedings.
Okay, is that generally how the company recovers transmission costs? What in between base rate cases, the company places new transmission investment in the TCA. Is that correct?
A business as usual case, that is what we would expect. I'm not sure we're in business as usual circumstances right now.
Okay. The 120-day report does indicate that, though, that these transmission resources would be recovered through the TCA as the business as usual case, as you say. Is that correct?
That's the company's proposal, but again, I think that'll be decided in other proceedings.
Okay. Are you also aware of the company's recent commission application and approval for the Power Pathway project?
No, sir. I mean, it depends what you're asking. I am aware of the Power Pathway, but if you're asking if I was a party to that proceeding.
I'm just asking if you're aware of the proceeding.
I am.
Okay. And are you aware of the Power Pathway project? Again, I'm just generally is projected to cost around $2 billion.
I think it's a little less than 2 billion, sir. You may want to point me to that estimate.
Okay. Well, if it's a little less than 2 billion, I mean, I'm just trying to get to kind of general terms here, but between the Power Pathway project and the new transmission investment we've been discussing in the preferred plan and the 120-day report, would you say it's fair to estimate that combined, that results in 4 to 5 billion in new transmission investment?
Yeah, I think that's
Okay.
a fair approximation.
Thank you. And would you agree that that transmission investment is projected to be made in the next 4 to 7 or 8 years? Does that sound about right?
I couldn't tell you exactly the timing of that transmission. I don't
Okay.
have firsthand knowledge of that.
Would you agree that that transmission investment, or at least the majority of it, will take place after QTS begins taking service from the company?
I would agree with that, sir. I think that makes sense.
Okay.
I think it's a very staggered, long process of expenditure over many years. So what that looks like in detail, I'm not really sure, but I would agree with your assessment that most of that is likely after this ECA would go into effect, which is 2025, if everything goes forward.
Okay, and as you described in the business as usual case, those transmission investments would be recovered through the TCA before they're placed into base rates, correct?
Well, I think you're repeating a question we've covered. I mean, I think that's the company's proposal, and that will be determined in other proceedings.
Okay, so when these transmission investments that are included in the TCA, when they're recovered through the TCA, QTS will not be paying for those investments under the company's proposal. Is that right?
I don't think that's entirely true. I mean, those investments, if they go to the TCA, would be rolled into the company's base rates periodically through rate cases.
Right, and when before they're rolled into the base rates, they'll be collected through the TCA, which QTS will not pay under the company's proposal, correct?
I would agree that we've proposed that that QTS does not pay the TCA.
Okay, and so transmission investments that are included in the TCA, if QTS is not paying for the TCA, other customers will be paying the TCA and paying for those investments, correct?
I think it's a fair approximation that, or a fair statement that based on your hypothetical, those costs are in the TCA, QTS would not be paying them, whatever those costs may be.
Okay, and under the company's proposal, once those costs that are in the TCA are rolled into base rates in a general rate case, QTS will begin paying for those transmission investments at that time. Is that right?
QTS will get a discount on base rates through their EDR TCAs, but I generally accept, yes, they'll be paying their contractual obligation on the transmission investments.
Okay, so when transmission investments, let me back up. Under the company's proposal, when transmission investments are in the TCA, QTS will not pay for them. But when they are rolled into base rates later, QTS will pay for them. Is that right?
Yeah, any costs that are in the TCA, once they're rolled into base rates is when QTS would pay for them.
Okay. Can we please pull from the box hearing exhibit 502, which is the company's response to a CEC discovery request?
Mr. Rushoff, just to give you a heads up, probably about 10 minutes, I think I'm going to want to take a break in the public portion so we can go into our confidential session to end the day. So if you get to a good breaking point.
I might be able to wrap it up. I'll do my best. Okay. The hearing exhibit 502 is PSCo's response to discovery request CEC 1-8. And if we can scroll down a little bit, this was sponsored by Mr. Wishart. Mr. Rupp, I'm assuming since you've adopted Mr. Wishart's testimony, you're able to speak to this response?
Yes.
Okay. And if you'd like to take a minute and review the question and response, and please let me know when you've done that.
Thank you, I appreciate that. Okay,
Okay, I'd like to move for the admission of this hearing exhibit 502.
Any objection to the admission of exhibit 502?
No objection, although I'm noticing that it also references the company's response to CEC 17. And so I would request that that also be moved and admitted into the record.
Mr. Rushoff, do you have CEC 1-7?
I have it. I'm not sure that I have it marked at the moment. But I could do that.
Okay, what we'll do, if you would please do so, you could just resubmit, we'll wait to take possession of hearing exhibit 502. You could prepare the exhibit with both responses, and we'll just continue using 502 for that.
Okay.
So what I'll do
Can
is describe that we will admit hearing exhibit 502 that will be Public Services response to CEC 1-7 and 1-8, and we'll get that document prepared for tomorrow. We'll pick it up in the morning.
Okay, we'll do.
Although if you're going to ask questions about it, we may need to change that approach.
Well, I would like to ask questions about just the response here before the, please see the company's response to CEC 1-7.
And I won't object at this point in time to questions about this particular document, absent inclusion of the other.
Okay, all right, then, so 1-7 and 1-8 responses, we'll get that document together for the complete exhibit 502 in the morning. Once we get that sorted out, let's go with the question and see where we get to.
Okay, thank you. Mr. Rope, would you agree with me that the gist of this question, 1-8, is asking Mr. Wishart to explain, I guess, asking the company to explain why QTS will not be charged the TCA? Is that generally your understanding?
yes, sir.
Okay, and in response, the response states that not charging the QTS the TCA is consistent with the Commission's findings in proceeding number 23A-0330E. And it says this is appropriate because new investments recovered through the TCA are driven by new and future customer growth, not by existing customers, including EDR customers. You've reviewed that language, correct?
Yes.
Okay, so I want to clarify this response a little bit. Is it the company's position that the Colorado Power Pathway project and the transmission upgrades identified in the 120-day report are driven by new or future customer growth?
Could you rephrase that or just repeat it for me, please?
Yeah, sure. Is it the company's position that the transmission investments we've been discussing, the Colorado Power Pathway, and the investments identified in the 120-day report are driven by new or future customer growth?
I would say that they're driven by the clean energy plan.
Okay.
And the requirement to meet the 80 by 30 target.
Okay, so that's not necessarily all this investment in the 120-day report isn't necessarily just meeting new customer load. Rather, it's meeting new clean energy targets or new state policies, correct?
Yeah, we need the renewable energy to serve existing load.
Right, and the transmission investments, for example, the Power Pathway project, the purpose of that is it was able to reach new renewable investment, new renewable generation in Colorado Eastern Plains and bring it to load centers. Would you agree with that?
Yes.
Okay. And some of the transmission upgrades identified in the 120-day report, the purpose of those are to improve reliability for new intermittent resources in the Denver metro area. Is that right?
I think you're a little outside my wheelhouse.
Okay. That's fair. I want to look at the next, we just read it, but specifically kind of the second part of that sentence I just read. The response statement that says that new investments recovered through the TCA are driven by new and future customer growth and not by existing customers, including EDR customers. Regardless of the purpose of these new transmission investments, all of the company's customers currently pay the TCA, correct?
Correct.
The TCA is not only paid by new and future customers, right?
No, sir.
Okay. So is it accurate to say that it's the company's position that QTS should pay for new transmission investment once it's rolled into base rates, but should be excused from paying that same transmission investment when it is recovered through the TCA?
Yes, that's what we propose.
Okay. And is the company's position the same with respect to the power cost, the PCCA?
Purchase capacity cost adjustment?
Thank you.
Yes.
Okay. So QTS should pay for purchase capacity once it is rolled into base rates, but not when those costs are recovered through the PCCA, correct?
I think it's a fair description of the company's position.
Okay, thank you. Those are all my questions.
Okay, thank you, Mr. Rishaw.
Your Honor.
Yes, Ms. King.
Thank you. With apologies for interrupting the stream of things, I just wanted to report that Exhibit 502 has been updated now in the box.
Okay, Ms. Federico, can you get the updated version of Exhibit 502 and take that into the commission's possession?
Yeah, did you want me to screen share it or just drag it in?
Want it both?
Got it.
Okay, we now have hearing Exhibit 502 consisting of two CEC 1-7 on the first page and page 2 of 2, CEC 1-8. Any objection to using this record now in the commission's possession for Exhibit 502?
No. And thank you for the quick turnaround.
Yeah, thank you, Michelle.
Previously admitted, but now we've confirmed that we've got the right document in the commission's possession. Thank you for that, Ms. King. Mr. Fanyo, you have some time, but it is 4:30 and this is where I wanted to stop. So we'll pick up with Mr. Fanyo in a public session tomorrow. What I think we're going to do is announce for the benefit of the public that we're now going to be going into a confidential session momentarily. We will conclude the hearing at the end of the confidential session and resume tomorrow at 9 a.m. And with that, Ms. Federico, if you would please.
Your Honor, before you go into confidential, just one quick one. I have no problem with starting tomorrow. I would appreciate if we could see the full Exhibit 502, the response to 1-7. I, off the top of my head, don't remember what that says, and it would be useful to know in the context of this cross-examination.
Okay, I believe you would have read-only access to the box.com folder, but Ms. Federico, perhaps you could put it on the screen for us a moment again.
Okay, I have what I need there. Thank you.
Okay, thank you.
Um,
Okay, so we will now
Your Honor?
stop. Yes, sir, Mr. Opp.
Just wanted to let everybody know I have some news that makes things a lot less complicated. Where staff was able to re-review the information that we're talking about. We're able to use public information from this other proceeding. So the issue about the highly confidential information is now moot.
Very well, but that then leaves you with potentially some cross-examination of a public nature.
Right.
So we will pick that up when we pick up. We'll have you probably pick that up before we get to Mr. Faneuil in the morning then.
Right, and that's why I brought that up now.
Thank you. Okay. All right, now we will cease the webcasting and begin the public session tomorrow. We'll go through again if anyone is on the morning to the public at 9 a.m. I'm wondering, are the parties available? Could we start at, say, 8 a.m. tomorrow and pick up our confidential session?
That would be painful.
The company will be available as you please, Your Honor.
CEC is available, but we don't want to cause pain for Mr. Faneuil.
8:30 would moderate the pain.
Okay. I was tempted by 8:30, so we'll go with 8:30 then. So we
Perhaps,
will
I
be,
believe, is Mr. Wright, Mr. Wright is not in the same location. If he is still on, just wanted to confirm he's available before 9, because I understand there's some confidential questions for him.
Yes, Fields, I'm available at any time.
Great, thank you.
Yeah.
okay, then we will recess for the evening. We'll pick up at 8:30 tomorrow morning with Mr. Rurup and Mr. Faneuil. And anything further we need to address tonight?
Just a question, are we then continuing with the confidential cross-exam of the other witnesses as well before we go back on the public record?
My anticipation is we will stay in a confidential session until 9 a.m. and then we'll resume the public session as I've announced. If we're not done, we'll figure something else out. I'd like to finish the confidential. That's why I wanted to start at 8.
I understand.
But we will see you all in the morning at 8:30 a.m. Thank you very much. Have a good evening.
You too.
Thanks for doing the confidential separate.